34 में करेंगे counsel prays for withdrawal of the petition with liberty to approve legal court. Dismiss as withdrawn with liberty.
And on budget, despite the states anticipating the legal that for past 4 years, the shop has been operated on the same.
Request में लिखवा देंगे. They've given you 3 days time. Wait for your turn. This bench is not hearing service matter.
No, it's not.
You have been terminated. What you said? Slip दे रहे हैं. आपका नहीं आएगा. नहीं आएगा. September last. September last time. Which case? I'm check कर. Request lady. That's the line of
I'm bringing second.
second line.
Number 1. He's not. The son of the petition is to fight this convention because of the extreme order. Application for litigation has been partly allowed not to you. And to see that you discussed one of the intention of the petition just to survive. That I placed the record around with document number 7566. And because like page 15. The subscription package.
बताइए. हो गई. Counsel content petition is rendered ineffective. The same stands dismissed having read and बाकी सबकी हाजिरी. State. State के लिए कौन? Pass. अरे जैसा बताएं करना हो तो पास ओवर करें नहीं करना तो नेक्स्ट वीक करो. पास हो. सही. P9. P9 is page number 560. 560.
You decide my lord, representation within the period of 90 days.
They have decided or not?
No, they have not decided, my lord. And the problem being faced by me, my lord, because of their delay, at the same time, I have taken insolvency proceedings, my lord, by one of the lenders. This amount, my lord, goes directly to the lender. The amount which is paid by them.
goes directly to the lender. And because of the delay,
Have you initiated content proceedings or not?
no,
Why?
because they were supposed to, my lord, just determine the figure, my lord, then intimate, my lord, to the banker.
Hmm.
Nothing has been done, my lord, presently to the best of our knowledge.
You file contempt petition, that is the only remedy, because there is already an order by this court.
That's one part of it, my lord. The second part is an idea which has been made by us.
Hmm.
The NCLT was graciously, my lord, extending our fees, my lord, for want of termination by MPI.
Hmm.
But now, my lord, they fixed it for pioneering on third. With the absence of any communication from them or any further orders from the court, my lord, I would be declared an installment balance and the last will be approved. The amount is exactly the same as payable by them. So presently, my lord, there are two releases made in the REA. One is, my lord, the direction to them, my lord, to at least issue a communication determining the amount. Payment may be deferred, my lord, but the amount determination has to be done by them, my lord. And B, my lord, for the time being, the NCLT may be directed to maintain status quo or adjourn the case, my lord, as the case. Otherwise, my lord, for want of this exact amount, my lord, well-balanced company declared an insolvent. P6, my lord, the earlier communication that
Mr. Nema, when final relief cannot be granted, how your interim prayer can be accepted? Because देखो, your final prayer is decision on your representation,
my lord,
and there is an ordinary order of this court
my,
for taking decision on your
my,
representation. Now you are trying to get something indirectly by way of interlocutory applications, whether it is permissible or not.
I'm not sure if my lord would just look into the facts, my lord, of the case. At least the status quo for the NCLT matter might be granted, or my lord, we
So what will be the ultimate relief in these petitions?
the ultimate relief would be,
What
my
will
lord,
be the final order in this
final
petition?
order would be the direction of payment, my lord. But includes
For that, there is already an order on your
the
previous petition.
for deciding the representation, not for the payment. Now, P6 may be seen, my
So
lord.
by way of decision on representation, you are virtually seeking payment only.
If
That is your prayer.
payment may be deferred, my lord, because it all depends on the financial history, my lord, as well when they have the funds, my lord.
Hmm.
They already constituted a committee, P6, my lord, is on 24th of October 2025, my lord. Now, the committee just has to determine the figure, my lord. The tentative figure has also been indicated in that particular communication, my lord.
RP has been appointed.
No, my lord. Third is the final hearing, my lord.
बताइए क्या क्या?
Part of it is already there.
Hmm.
Remaining balance for the far as the IT is concerned, they not have any please.
When you are going to take decision on their representation, because if you take that decision, then the controversy can be brought to an end. Where is your IA?
We are able to build up in China. Unfortunately, nice.
Hey,
Even I know that is underneath it.
what is termination payment?
Clause said that for any that is terminated, then 90% of the debt would be paid by MPI. Debt was 66 crores, so 90% thereof was paid by. They had paid my lot only 80%. So the remaining balance is yet to be paid, and that goes directly to the lender money.
That is required to be paid to you,
No, to the lender,
to the lender.
to the lender. And the lender in the meanwhile, my lord, there are two lenders, State Bank and IIFL. State Bank is staying put, my lord, but IIFL has initiated this IR for that value. This is exactly the same figure which they've already determined, but then of course there are logistics, my lord, on their part.
You included IFR as a party.
My lord, I think it's responding to the four.
Respond number 4.
Four.
Issue notice to the respondents on payment of process fee within 3 working days. Returnable 3 weeks. Is the matter in last week of July. Till next date of hearing. Further proceedings pending. We also heard on IU 7. Till next date of hearing. Further proceedings of case number है क्या?
Yes, sir.
Restored CP यही नंबर है.
Yeah, but earlier it was dismissed for want of it was restored.
Proceeding in restored CP within bracket IB/2/2025 pending before National Company Law Tribunal Indore shall remain. State.
Yes.
Lordship, this writ petition is seeking for a direction given the representation which is in annexure P1 and which is not been decided yet.
P1.
Lordship. In the lieu of employment इन्हें पैसे देने थे Lordship. वो अभी तक
किसको who has to decide this representation?
Respondent में 2.
P1 to be dealt with by number respond number
2 Lordship.
2. C30. No opinion on merit, wisdom. Disposal. Next.
Obliged.
Right.
ये आपका रिवीजन P7 से डिसमिस हो गया है. Issue notice PF7 7/4. हाँ. Let private respondent come. Issue notice to the respondents 7 days, 4 weeks. Till next date of hearing, parties are directed to maintain a status quo. The objection taken by the state regarding maintainability of the petition regarding Filing of petition under Article 226 of Constitution instead of Article 227 of the Constitution, shall remain open and shall be dealt with on the next date. Yes, status quo.
One, I have completed on 49/2023, graduate election P4/150.
What was completed?
Yes, that has been completed, but that is P5/150, P4/154.
Then what happened?
But now, after 3 years, I received this so-called notice. Connected P5/156 on 30th March 20. Stating in earlier that the report of the seabed, which I have submitted, is alleged to have been false and false. Therefore, I was afforded an opportunity of hearing to submit my reply within a period of 3 days. Well, I have categorically stated in my petition, right, paragraph 5.7, that I approached to the authorities and demanded the documents over which such a so-called notice has been issued. That is paragraph 5.7. Now, my lord, respondents have issued the further notice on 24/4/26, contained in annexure P6, page 158. And the last line, my lord, Okuro,
Yes.
page 158, annexure P6. उपरोक्त तथ्यानुसार यह साबित होता है कि आपके द्वारा फर्जी दस्तावेज प्रस्तुत किया गया, अतः आपको निर्देशित किया जाता है कि अनुबंध की कंडिका 8.2 पेज नंबर सच एंड सच के अनुसार प्रदान किए गए सभी फाइट की निम्नानुसार 100% राशि 89 लाख बतौर एफडीआर नियमानुसार इस कार्यालय में प्रकरण के अंतिम निराकरण तक जाए. The inquiry has not been conducted. No independent inquiry has been conducted. And now they are asking us to deposit this 89 lakhs rupees for the purpose of our pending the inquiry.
When this work was completed in the year?
The work was completed on 14/9/23, C4, page 154.
And the entire payments were made?
Yes, everything has been paid, everything is done. I've received all the payments, even the security deposit has been refunded. And now, my lord, to add more to my injury, my lord, they have passed the notice on P8, page 162. Saying that if you do not deposit the amount from the ongoing tenders, we will recover them.
Yes, बताइए.
I told you. The bid was accepted and work order was put on. There are under agreement for a probable amount of contract. We might not describe. We might
कौन सा क्लॉज है arbitration? Is there any clause for arbitration in the contract? बताइए.
Responded was to very good.
Once contract concluded, payments were made. Contract concluded, entire payments were made. And ultimately, now there is no agreement in existence as on date. वो तो work हो गया. There was a successful completion certificate also, and the payments were made. Now at this stage, that condition can be invoked or not. क्या क्या काय का contract था ये? What was this contract?
So it is for retrofitting of the pipelines for the purpose of water. Which 156 P for
156. हाँ.
तो इस तरह के अंगीक क्रमांक 600 प्रदेश क्रमांक 600 तो जल जीवन मिशन योजना अंतर्गत नल जल योजना प्रदाय योजना के क्रियान्वयन में अनुबंधित किया जाता है जिसमें आपके द्वारा सामग्री को किराए पर उपयोग किया जाए इसलिए मैडम ये कैसे उपयोग किया जाएगा ये आया सेकंड लास्ट पैराग्राफ में आपके द्वारा उपलब्ध कराए गए अभिलेखों को अनुसार उन पाइपों को प्रदाय पूर्व इंस्पेक्टर सेंट्रल इंस्टीट्यूट ऑफ प्लास्टिक इंजीनियरिंग एंड बैक्टीरिया और सीपेट के रिपोर्ट दिनांक के द्वारा किया गया सेंट्रल इंस्टीट्यूट ऑफ प्लास्टिक इंजीनियरिंग एंड टेक्नोलॉजी सीपेट के संदर्भित पत्र द्वारा सीपेट रिपोर्ट की जांच करने के लिए बताया गया कि रिपोर्ट को संबंधित निरीक्षक द्वारा इस तरह द्वारा जारी किया गया इस संबंध में आप अपने स्पष्टीकरण ये संबंधित सभी आवश्यक कॉन्ट्रैक्ट लिए कॉन्ट्रैक्ट के लिए आएगा कि और आपको कोई चीज उपयोग की गई है सप्लाई की जरूरत है उसमें आएगा उसमें ऑर्डर का भी मेरे पास क्वालिटी एक्सपीरियंस लेटर सकता फंक्शन कोई भी कॉन्ट्रैक्ट से संबंधित विवाद है आगे देखने के बाद
नहीं, that is not the issue. Issue is that कि when the work was completed and a completion certificate was issued, that is page number 154. Entire payments were made. So after 3 years, can you take this step or not? This is the question. क्योंकि खत्म हो आज की डेट में कोई एग्रीमेंट नहीं है ना ही कॉन्ट्रैक्ट कोई रनिंग. It is contended by senior counsel that it is a case where the petitioner was awarded the work of design and construction of retrofitting of piped water supply scheme under Jal Jeevan Mission at village Pasadi, Bamori, Karela, Jagua block, Padwara, district Patni. The works too awarded to the petitioner was successfully completed by him and accordingly a work completion certificate by Annexure P4 dated 14 and 23 was issued to the petitioner. The entire payments under the contracts were made to the इसकी payments हो गई थी ना आपको made to the present petitioner. However, to the misfortune of the petitioner, almost after lapse of 2 years and 6 months now, a notice dated 30/3/2026 by P5 was issued to the petitioner, calling upon the petitioner to submit its reply regarding a report given by Central Institute of Plastic Engineering and Technology regarding the pipes which were used for the execution of the work. The petitioner appeared before the respondent and demanded certain documents. However, the documents were not supplied to the petitioner and thereafter, the notice dated 24/4/26 P6 as well as, Another notice dated 19/5/26 P8 has been issued and there is imminent threat of recovery of the amount which is mentioned in the notice. Issue notice to the respondents, we have 7 days returnable, 4 weeks till next date of hearing, comma. No coercive step shall be taken against the petitioner in order to recover the amount which is mentioned in Annexure P6 dated so and so and Annexure P8 dated so and so till next date of hearing. Password.
Disputed that is self-equivalent of the mother. It not be notice of 1993. So there to be another discussion number. Overall 5 hours, department lesson within disputed land. Subsequent period, volume 16 I have tried to अपना पंचायत टाइप देने को क्लिक करिए नंबर 30 without any information without any publication आप के लेवल but either the land is located in the ward number 4 Bhawar petition referred an application the section on 15 of the MPL of the correction of the
This order of collector is further revisable. तो कलेक्टर का ऑर्डर रिवाइजेबल होगा ना?
original order is passed by subdivisional officer.
अरे जो P10 का ऑर्डर है आपकी अपील खारिज कर दी, P10 से कलेक्टर ने अपील खारिज किया ना, तो ये ऑर्डर तो रिवाइजेबल है कि नहीं है? वो कौन सा प्रोविजन बताइए?
Original section is 1.5.
Issue notice to the respondents, give 7 days returnable, 4 weeks till next date of hearing. Parties are directed to maintain status quo as obtained. Notice status quo.
Till then the respondent number 4 has not cleared the third party. Which is known as
You will maintain status quo.
Has elected the association of commissioners, taking direction for respondent number 2 to return 1% previous amount
That was deposited at the time of the property as per the sale contract. Next is given is the decision of
This order is
bill number 14.
the order is by recovery officer.
Yes, ma'am.
Then assail it before DRT only.
At present, there is no presiding officer in that clarity and only option option possession matters are only being taken up by the Ahmedabad bench. Or there is no minority available, that's why this.
Have you approached DRT or not?
Filed an application before the recovery officer. That's the next step we will be number 16.
Are you against the order of recovery officer? Have you approached DRT or not?
No, no, no. In the recovery officer order, the report is on the court act. Filed the application.
Why you have not approached DRT against the order of recovery officer?
I am the solution that because the filing officer is not there in reality.
That is your apprehension, but have you approached or not? Or you have filed and they are not taking up your case? Or you have not filed your case at all?
For the DRT matter,
So then file it and make a request before DRT, then come to court. Withdraw it.
only option possession matters have been taken.
You file, make a request. If your request is not exceeded, then come to court. Additional praise for withdrawal of the petition with liberty to approach DRT. Petitioners are withdrawn with liberty.
Problem is complete before the registrar public persons in February 2022. The purpose will be transfer of the trust service and trustees have been attracted by the trust. And in terms of section 9 of the public trust act, application has been made before the registrar public trust.
E1, that is pending.
Being sealed by the application to distribute pending cases. Now pending cases are those which he himself appointed trustee and those proceedings have been stayed by the state. Those are orders are included.
Let him take a decision on this. P1, prayer court, submit that. Submit that application is submitted with Forestar Public Trust by Denuncia P1 and comma. This said application comma is required to be dealt with by the registrar in accordance with section 9 of the MP Public Trust Act. Council contended the registrar be directed to take decision. Conceding the Northwest Prayer, respondent is directed to take decision on application P1 within 60 days. 60 days. Speaking order. You're filing it today. Let it be taken on Friday. आज file कर this case Friday. I have to continue this Friday.
Developed by the response right for number 561. One release complaint of the party. One number 4 Tehsildar conducted inquiry by Major 341. Page number 20. Directed the respondent number 5 Gram Panchayat and Concerned Company leaving the land of page number 20 of the 96. Next step P4 page number 2. प्रकरण का अवलोकन किया गया सारा दस्तावेज को परीक्षण किया गया आवेदक के अभिलेख पत्र का प्रकरण पूरा दस्तावेज और उनका फोटोकॉपी प्रक्रिया पर निगरानी भूमि को भूमि के मुझे सड़क कंपनी ग्राम पंचायत केवल काम द्वारा व्यक्ति का चयन किया गया है। का ग्राम पंचायत केवल कंपनी को आगे किया जाता है कि वो जमीन में काम करता है। उसके बाद सर हमने कोई कोई कार्रवाई नहीं हुई, तो ट्राई करने के 36 है, ट्राई करने के 36 पेज नंबर 26 फिर से कहा कि तुम्हारे वजह से पालन किया है। 2021 से बहुत परेशान है, 2021 से हमारा काम नहीं किया, हम इसीलिए नहीं कर पा रहे हैं। उसके बाद हमने 57 में कलेक्टर कंप्लेंट भी किया।
It's contended by the council for petitioner that an order caused by Tehsildar Mohghed district Chindwara dated 30/12 P4 is not being complied with. There are direction, strict direction by Tehsildar to level the land which is owned by the petitioner as much as the land on account of massive digging and excavation is no more cultivable. It is contended by the council that no compensation to the petitioner was paid. However, amount was paid as well, and no action on the grievance of the petitioner is taken. Petitioner has also approached collector by way of representation contained in P7. Submit that collector be directed to take decision considering the notice prayer without expressing anything. Merit collector Chinwala is directed to take decision on petitioner representation P7 within a period of 30 days from the date of production of certified copy of this order.
हमारा एक ऊपर प्रस्थान हो जाता है, तो इन्होंने जमीन जिसके बाद उन्होंने रोड निर्माण किया था पेज नंबर 24 इसमें कोई डिस्प्यूट नहीं था। 2/2 ने बात किया है, 2/3 भाग गया था, बट गया था। अब ये इसका 24 कर रहा है लॉर्डशिप, और हमने सीमांकन का आवेदन दिया हुआ है एग्रीगेट फी फाइल में। हमारा से कितना निवेदन है कि हमारा सीमांकन क्योंकि ये हमारी वाली लैंड से कर दे रहे हैं, तो हमारा आवेदन डिसाइड कर दे, उसके बाद
कौन सा एप्लीकेशन
P7 में लॉर्डशिप हमारा आवेदन जो हमने दी हुई, और P5 में लॉर्डशिप हमने सीमांकन का आवेदन दिया हुआ है।
Court counsel contend that an application has been made by Director P7 before sub-regional officer Batu. Counsel contend that the said authority be directed to take decision thereon. Consulting the notice for SDO, Batu is directed to take decision P7 within 30 days.
आवेदन दिया है, 82/24 का सीमांकन बस उसको सीमांकन करने के बाद निर्माण करा जाए।
That will be decided all. No problem. You will pay the compensation even if they construct public project करना है तो
जो हमने 2002 में एक्वायर किया था, उसपे हम कोई डिस्प्यूट नहीं कर उसको
let authority will take decision. No interim order.
बस इसको सीमांकन की बात करते हैं। no सीमांकन चाहे 7 दिन निकलने
Prayer is rejected. So application be decided within 15 days कर दी.
yes
P7 बस और कुछ.
40 not challenging and specific matter, but taking direction to grant permanent. पहला हम 43 से उत्पन्न में रह रहे थे उस समय के महाराजा गुलाब सिंह सुखदेव उन्होंने पट्टा दिया था, और सर 2017 में कलेक्टर ने हमारे फेवर में ऑर्डर पास किया था कि इनको जो है इंक्रोचर नहीं, इनको बसाया गया था बाजार में, इसलिए जो है इनके खिलाफ 248 के खिलाफ कार्रवाई भी नहीं।
हाँ कलेक्टर का ऑर्डर कहाँ है? पेज नंबर
सर 31
31
सर वो मेजर की फौज में सर एलपीओ ने रिपोर्ट किया सर यहाँ 2009 में सर
इंक्रोचर मानते हुए सर तहसीलदार ने हम लोग को बेदखली का ऑर्डर दिया था और 2009 में सर हमारे खिलाफ जो है वो बेदखली वारंट जारी हुआ था और 4/11/2016 को आवेदन कोर्ट में सर लियाकत अली ने फाइल की थी अब जिसमें की डायरेक्शन हुआ था कि रिकॉर्ड देखकर और इसकी जांच करके जो है रिपोर्ट सबमिट करें। तो सर एसपीओ जो है P4 में सर उसने रिपोर्ट जारी की थी कि ये प्रोसेसर में है और ये 46-47 से वहाँ पे है। तो सर हमको परमानेंट पट्टा के लिए इनिशिएटिव इसका हमने प्रतिवेदन दिया हुआ है सर धारणा अधिकार प्राप्त के लिए है, जबकि सर स्थायी पट्टा है।
अरे तो ये कलेक्टर ने ऑर्डर किए थे कि पुराने बेदखली के ऑर्डर रिकॉल किए जाएं, तो रिकॉल हुए कि नहीं हुए?
सर होगा
वो कहाँ, रिकॉलिंग के ऑर्डर कहाँ है? ये तो कन्फ्लिक्टिंग ऑर्डर है। पेज नंबर 35 पे कलेक्टर ने बोला था ना।
जी कलेक्टर ने बोला था सर तो हमको वहाँ से हटा नहीं रहे हमको धारणा अधिकार दे रहे हैं।
अरे जो बेदखली के ऑर्डर को रिकॉल करने के लिए कलेक्टर ने डायरेक्शन दिया था, वो ऑर्डर रिकॉल हो गए। पेज नंबर 35 का पैरा लास्ट पढ़िए, पैराग्राफ 9। ये पुराने बेदखली के आदेश थे आपके खिलाफ, ये रिकॉल हो गए कि नहीं हो गए?
हमको दिए तो नहीं है लेकिन हमारे ऊपर कार्यवाही भी नहीं की।
हाँ, तो आपको पता करना पड़ेगा, उसके बाद पिटीशन लगाए, क्योंकि अगर वो ऑर्डर रिकॉल नहीं हुए तो कॉन्फ्लिक्टिंग ऑर्डर हो जाएंगे। पैरा 9 पढ़ा ना आपने?
जी
तो जब तक ये क्लियर नहीं होगा कि पुराने ऑर्डर रिकॉल हुए कि नहीं हुए, डायरेक्शंस कैसे देंगे आपको? तो पता करके बताइए ऑर्डर रिकॉल है कि नहीं। पिटिशनर इज डायरेक्टेड टू सीक इंस्ट्रक्शन regarding the recalling of order of disposition as advised by collector. Void is order dated 23/2/17 contained in annexure P5. This is the matter in the next view. This is a petition by bank. Then what happened? Then approach the authority. You approach Tehsildar. He has issued notice P4 already. The grievance of the petition regarding the implementation of order contained in P3 dated 2/3/24 passed by Chief Judicial Magistrate. It is contended by the council that this order is required to be executed by Tehsildar Chandwala, who has issued a notice for taking possession of the property. Void annexure P4 dated 24/12/25, however, as on date, the possession of the property has not been taken. The petitioner has also approached district magistrate while representation by Dwara Dojar Sanchez. This contained in page number 29. Having considered the submission provisional of the report, provide that the petitioner is seeking implementation of the order passed by Chief Judicial Magistrate, which is required to be executed by Tehsildar Chandwala, who has also issued a notice by annexure P4. Thus conceding the prayer made by the present petitioner on a petition stands disposal with the direction to respondent number 3 to take the steps for possession of the property as initiated by notice dated 24/12/2025 P4 within a period of 30 days. If there exists no impediment or embargo, else the reason for the same be communicated to the petitioner within the aforesaid. No opinion on merit, dispose of. Next. तो आपने गवर्नमेंट प्रॉपर्टी पे बनाया हुआ है? प्रॉपर्टी गिरा लीजिए, जितना इलीगल है वो गिरा लीजिए। हाँ ये है तो आपकी प्रेजेंस में तो किया था ना।
उतना राशि का नक्शा बनी नहीं किया गया।
ये P1 में जो ऑर्डर आ रहा है सेकंड लाइन में कहाँ है? 10/7/2023 को P1 की सेकंड लाइन पड़ेगी।
अभी 10/7/2023 को मध्य प्रदेश शासन की कुआ राजेंद्र प्रसाद पक्का मकान निर्माण कार्य किया गया है जो सातवीं भूमि अधिग्रहण का सार्वजनिक विस्तार प्रभावित हुआ है। आवेदक सामान्य हुआ केवल द्वारा संपर्क केवल में चले मुख्यमंत्री में आता है।
ये 10/7/23 का आदेश कहाँ है? ये बना क्या? दैट इज द मेन ऑर्डर विच इज रिक्वायर्ड टू बी चेंज। वही ऑर्डर तो एग्जीक्यूट हो रहा है। Petitioner is directed to place on record order dated 10/7/23 passed in revenue case number 0002/A-68/23/24. Reference of which finds mentioned in improving order dated 8/5/26 P1 passed by SSC. This is the next week. रोज मत वो देंगे नहीं। There will not be an interim order. आप कल कर लीजिए, ऑर्डर बुला लीजिए। Let's tomorrow. हाँ हाँ
Now, going back to the finding that they're going to start next part is the year 2017. After that will be started execution of this agreement. And we concluded the executing court to attach the property. Right, attachment documents from the that file the copy of the attachment. Now, what is that? While the attachment proceedings were going on, I approached guy to compromise that. When it is created person, and I deposited the entire outstanding to the now, when I approached the bank to obtain my payment that was mortgaged, I was informed that the property was sold long back in the auction in the year 2014 under SARFACIA. But this affidavit was filed in the year 2025
Now, the banking authorities, what should they not to suppress this material tax before the trial? And also, though the property was already sold out in the year 2014, they again proceeded to execute the legally and proceeded under the rule of tax schedule for attachment of the property. Now, I filed an application under to the new section 379 code section 340 and with 195. And I also made various objections. The executing code they did not decide the object. And the proceeding since the bank has filed an application for withdrawal. So the executing code is simply they have fixed the matter before you allow it for withdrawal. But they now the application is not decided now. So the kindly come to excessive. That is the order in which my application has been taken up by the
A3 page number.
35. The value is here. The matter was heard today with respect to the objection raised by the city at the state of consideration of the application filed by the PHP under 379 to 250. Now, these are the submissions which are recorded by the executive recovery of the watching the value by the next. The application is not yet is not waiting by the what should be guided about the specific provision? There is a specific provision. At the 379, the inquiry has to be directed for the offences that are mentioned under 200. So one of the offences that is section 347 of PNS Act in IDPC that's generally applied by case and for that purpose inquiry is required to be ordered. What should be guided along to section 247 of PNS Act. Coordinately obtaining between some of these.
This order is by recovery officer.
Recovery officer is not reading that. He is also not reading by objections, but they only on the count. The recovery officer says that I have raised certain objections on the previous count. Those objections, after those objections, that objection was not.
Why don't you challenge this order of this recovery officer, page 34 order, page 35, by approaching DRT?
Under section 30 appeal is only available for the purposes mentioned between 25 to 20.
निकालिए section निकालिए.
And one more thing, what I am seeking in this
Recovery of debt.
what I am seeking, what direction I am seeking in this case is the by 379 application will be decided. Because since the application is not even decided, so that order cannot be appealed. Now I really close my IDPC.
That is decided.
So this is not 379 application is not decided.
That is decided. Come to paragraph page.
Objections deduction by kindly penalty is 60. That objection is decided, saying that since I have decided the earlier objection, 379 application is not decided. 379 is procedure under 379 is kindly be seen. Procedure, what the procedures to be followed by the executing court of
निकालिए.
Yeah, the 379. Proceeding
379 of BNSS. Yes.
procedure in cases mentioned in section 250. When upon an application made to it in this behalf or otherwise in court concluded that it is expedient in the interest of justice, that an inquiry should be made into any offence referred to in section referred to in clause B of subsection 1 of section 250, which appears to have been committed in or in relation to the proceeding in that court, or else the case may be in respect of document produced or given in evidence in a proceeding in that court, such court after such preliminary inquiry, if valid, as it thinks necessary, record of findings will be indicted, make a complaint thereof, send it to the magistrate, take sufficient security for the appearance of that plea before such magistrate.
or if the alleged offense is non-available and the court takes it necessary to use the tender perspective, I think the defendant might over any person to appear and give evidence before the court. Now, this offense under 247 is provided under clause 3 of subsection 1 of 215. Not to get any around to section 215.
But there's no order as on date on 379 application.
279 application, no, it has not been considered.
This is filed, 379 is filed by the certificate holder. That is by,
By the defendant. Because now not to get any section 247.
there is, read again, page 34. Read first paragraph of page 34.
Matter was heard to be with respect to the objections raised by the CD and the stage of consideration of the application filed by the CHP. This is right. CHP has not filed this. We have filed this. I have also filed a copy of the that is when it should be when it's for these objections, what the court said that I have decided, those objections may kindly see or may kindly turn out to page 63. These are the fresh objections which I have filed. ये पहले वाले objection certified copy.
So ultimately by this order, your application under section 379 was dismissed.
Objection, my objection for the time. Say that to see that since I have already decided with objection once, so I will not decide your objection.
What was your objection? You made objection in your own application. You made application under section 379.
So I made one application 379 and I made separate objection. I made various applications. One application was under 379. And there was a separate application, there was a second objection. That application is second at page 60.
No. Now you come, please come to paragraph 5, page 35.
If you watch it, I will produce the paragraph 4, which is the operating part of the order.
Yes.
Upon consideration of the submission and material available on record, the following orders are certain objections now sought to be raised by the students already stand adjudicated citing earlier orders dated 19 and 25. Admittedly, no appeal or challenge against the said order has been preferred. The CD therefore cannot seek substantially similar relief by way of repeated application to the authority. This the authority is talking about my objection, which is at page 60. Because I filed a second application, there is second more. This is
What kind of objection you made apart from your application under section 379? What was your objection? And what was the need to make any objection? You could have argued your application 379 and this is what the order on 379 application. Where is the previous order 19/2025? Where is that? What was this application on which this order was passed? 19/2025.
I am not entitled to the copy of the title. This is only decided in this order. This is not about 370. पहले कोई 379 applications के पहले फाइल नहीं. This is for the first time I filed a 379.
This is the application on which the 99 authorization is on the petition. This is the application on which we are talking.
Now, where is your objection, which according to you raised some objection
Yeah,
also?
Lordship, I kindly announce it.
Page? Page?
Page 63, that is the lecture. 9. Now my objective, very objective objections are at page 65. That is a goal.
Yes.
These are the objections of application for withdrawal, because they filed an application for withdrawal of the execution. So I find my objections to their withdrawal. Page 65 will kindly be turned out of these objections. It is submitted that the bank never apprised the debtor about the said sale to the debtor, and by giving false affidavit proceeded to issue proclamation of sale, and thereby proceeded to attach an option to slip property in the present execution. It is submitted that the proceedings sale in the present proceedings were only being made despite the property was sold long back, and the amount was already recovered and settled by closing the sale. As of the present, debtor has given false assurance and by misrepresenting the bank made to deposit the amount of recovery certificate, although the sale was already recovered long back. Thus, the bank has paid fraud with the present debtor and to hide its conduct now wants to withdraw the present execution proceedings by further claiming fraud to the debtor. Lordship will carry that on to page 67. And this loan account was closed in the year 2014 itself, Lordship, before the decree was passed. That document I have also filed along with that. Page 67, it is humbly submitted as paragraph M. The bank did not give any information regarding action, claim, and recovery of revenue loan amount to the tribunal, and on false pleadings filed an original application for recovery of amount. On the basis of ex parte judgment, the said OA filed this petition case for recovery, supported by false and frivolous affidavit of the official of State Bank to save the undue advantage. It is also important to mention that frivolous application supported by false affidavit for issuance of attachment warrant of mortgage property has been made by the State Bank that property is already sold and particular as per affidavit filed by the official of the State Bank. It is submitted that the certificate holder bank has filed this recovery for recovery of loan amount from 27,37,000 of never due or recoverable from the debtors. In fact, all deals were already settled on 21/6/2014.
So how your objection is maintainable unless paragraph 2 of this order is set aside? लिखाइए वापस में. Paragraph 2 of this previous order is, read this paragraph 2. In view of this paragraph 2, they have right to withdraw the proceedings. Nothing survives them. So you have to assail this paragraph 2. The executing authority itself is saying that they cannot execute. Nothing survives in this proceeding.
My saying is, they refuse to return the original title deed by the withdraw. You are not seeking the title return of title deed because the property.
To read paragraph 2, you forget title. Read paragraph 2, what is there?
As is evidently seen that said mortgage property of CD was already sold by the CHB in the year 2014 under Southern selection. There arises no question of this execution authority giving any direction to CHB for return of original title deed to CDs as the matter doesn't fall within the duty of the undersigned as action of sale already being conducted by CHB in the year 2014. But if I am not seeking this objection. The second objection was not about
Read further.
My saying is, Lordship, that because the bank has made false affidavit, my application which is 379 was a separate application to the objection. That application was to have been decided on merit as per the provisions of 370. And Lordship, I kindly turn on to the affidavit that has been filed by the bank. If this affidavit be filed Not to take any prolonged friendship physics, important.
You have to set ultimately, unless you are still that paragraph 2 of that order which is in your hand, nothing survives.
This
That's the thing.
for the purpose of 379,
Chill.
even if those
That we have already argued. दीजिए order वापस उनके पास दीजिए. Is contended by counsel for the petitioner that the objection moved by the present petitioner has been turned down by the recovery officer, debt recovery tribunal by order dated 25/2026. It is contended by the counsel that apart from an application under section 379 BNSS, comma, the present petitioner also moved an objection regarding proposed withdrawal of the proceedings by the bank. The said objection was taken up for consideration and has been decided by order dated 25/2026. It is contended by the counsel for petitioner that it is a case where the bank from the approach of the bank was was suspicious, and the bank, comma, during the execution proceedings disproved the factor that the auction sale of the property had already taken place on 19/3/2014, and the amount of rupees 10,11,934 also stood cleared on 21/2014. It is contended by the council that at the at that stage, comma, the present petitioner moved the aforesaid application under section 379 BNSS and also raised an objection regarding the action of the bank of withdrawal of the proceeding as, comma, the bank, comma, upon coming to the bank, comma, upon coming to know the bank, comma, later on comma, while taking reports to an altogether different stand, comma, needed to make a prayer for withdrawal of the recovery proceedings, which, comma, in turn has been referred to the Lok Adalat. Full stop. It is contended by the council that prior to the objection, the petitioner had moved an application for return of his title deed. The said application was turned down while the order dated 19/2024. However, comma, the objection of the present petitioner has been turned down by the recovery officer while making a reference to the aforesaid order dated 19/2025. Having considered the submission proposal of the report, reflects that before the recovery officer, comma, the present petitioner moved an application for return of the deeds full stop. The said application came up for consideration. So for recovery officer DRT and recovery officer DRT, comma, yes, was disposed of and ultimately, comma, the recovery officer, comma, observed in the order that the motive property of the present petitioner slash certificate debtor was already sold by the bank in the year 2014 under the Surfacing Act, and, comma, there was no question of there was no question of issuing any direction for to the bank to return the original title to the present petitioner. As, comma, the recovery officer observed that the matter did not fall within the jurisdiction of the undersigned, as the sale already stood conducted in the year 2014. The said order dated 19/2025 has not been assailed by the present petitioner. A perusal of the said order, comma, clearly reflect that nothing is required to be executed. Nothing is required to be executed, as the recovery officer has clearly held in this order, and therefore, comma, the any objection regarding proposed withdrawal of the proceeding by the bank, comma, was not maintainable unless and until the findings as arrived in paragraph Roman 2 by the recovery officer in its order dated 19/2025 are interfered with. The said order dated 19/2025 undisputedly has not been assailed by the present petitioner. Therefore, in absence of Any assault to paragraph 3 of order dated 19 and 2025, this court of the view that the recovery officer did not commit any error in passing the impugned matter. Hence, this court does not find its expense in the petition, the same stands to dismiss. Next. हाँ जी बताइए.
Settlement and some other cases to be done by phone number 6, 7, and 8. That secretary goes one and doing the notice of the well fantastic.
Who are you?
I think it looked a resident of the human. My lord, and this tax came to my knowledge that one is totally last few constructed being just near my house. And that was that this tax was known to me. Later on, he came, the petitioner came to know that the amount of obtained of surplus has not been constructed. Then he inquired me. Then he found that the animal tank, a tank was constructed by the petitioner's himself for the water to the animal of the village in the summer season. And that animal tank has been shown as the surplus constructed by the Panchayat an amount of 10. Then, my lord, the other petitions we are found when this corruption was made in knowledge of the petitioner. Then he inquired, then he came to know that the several other works which were to be carried out in the village Panchayat, for which huge funds was the.
You file PIL. You file public interest litigation.
It's not because this has been filed by the immediate capacity and because the local individuals are not, they are not aware. Still, they are not. When this fact came to the notice of the petition, then one software was to be constructed near his house. Then he came to know that his construction, his own construction for the animals has been shown by the Panchayat as significant amount of time. Then he inquired from his own. And under the RTI, under the portal from the Panchayati portal of the government, then he came to know about the mass corruption.
So mass
Then he dropped the.
For mass corruption complaint, you are required to file PIL. There is no individual grievance. Cause is waiting.
Respondent under the executive officer rules 1995. Respondent number 4 is the competent body to inquire the matter if such information of brought to the notice of.
Even for any direction for inquiry, you have to file PIL only.
Why not? It can be disclosed after to inquire the matter if they found.
There cannot be. You have no locus at all. There is no individual grievance.
I am the legal recipients. I tried with my best to find out.
Then you file PIL. It is good you are espousing social cause. File PIL. Withdraw it and file PIL.
One identical matter by the Court-18 bank it was directed by the matter and because the options are going on. और 7-10 महीने के बाद अब इसलिए वो एकदम खुलेआम कर रहे हैं तो इसलिए अगर वो इसका नोटिस के पास अगर उनकी इंक्वायरी होती प्रिलिमिनरी इंक्वायरी होती है तो इट कैन बी रिव्यूड बाय द अथॉरिटीज कि दैट समथिंग रॉन्ग because the proof find out the respondent number 4 is the competent authority to inquire the matter.
Yes.
That for that matter, like you mentioned, under Madhya Pradesh Panchayat powers and functions of chief executive officers in 1995. The PE of the Jila Panchayat is completed and statutory duty bound to inquiry. If such facts are brought to the notice of the situation. By humble submission, application can be disposed of directly to the respondent number 2 to inquire the matter. If it is found that some financial irregularity and embezzlements are there, then appropriate action may be taken.
So you have this present petition form, the petition is seeking a direction to respondent number 3 and 4 to take appropriate action against the private respondent as according to petitioner there are serious allegation of embezzlement, and irregularities against them. It is evident from proposal of the The perusal of the writ petition prima facie reflect that no individual cause of no there is no there is no individual cause of the petitioner which is being sought to be espoused by way of the present petition. The petitioner the petitioner is precisely complaining about the defalcation of the amount of public exchequer. It is for the petitioner, to file public litigation so far, inasmuch as, there exists no individual grievance for the petition. Accordingly, reserving the aforesaid liberty with the petition, this petition stands dismissed. Next. 190. ये 16/3/26 का ऑर्डर कहाँ पे कलेक्टर का एनेक्शर कौन पेज नहीं अरे तो ये issue notice. We have 7 days returnable, 4 weeks. Notice. Let them come. अरे आपका रिवीजन की अभी कोई इंटरव्यू रिलीज तो दे नहीं सकते कि उनका नोटिस E1 is an order filed under 129(5). P1. ये जो ऑर्डर है ये 129(5) पे तो नहीं हुआ ना P1 क्या है ये नहीं, आपका है कहाँ ऑब्जेक्शन कहाँ पे है 129(5) जो आपने फाइल करी
वो है सर
ये जो P1 का ऑर्डर है P5 पे ही हुआ है क्या
आपने फाइल की जय बदन बाबा जय बदन बाबा यूनिवर्सिटी यानी विंडो के पहले श्रीलंका में 1724 में 12/6/24
issue notice we have 7 days 4 weeks till next date of hearing parties are directed to maintain status quo as obtained today For matter of fact, no voting again.
Notices dependent team that you write it on shop here, which you depend on a degree, which depend about the shop, not with a rent of past 50 years, and even 50 years.
अभी P1 पे डिसीजन नहीं लिया है क्या? P1 इज योर रिप्रेजेंट.
उसे भी डिसाइड नहीं किया गया है, जबकि कंडक्ट ऑफ रिस्पॉन्ड की फीस और एक्चुअल डिग्री का पहला रेडी का अपडेट का रेडी बनकर सेलेक्ट किया गया. रियल मॉडल डिपेंड ऑन ये फाइनली रिप्रेजेंटेशन.
Let authority take decision on representation. Prayer for P1
Not we have
to be dealt with by respondent number 3.
not doing more than no course selection should be decision of representation.
They have initiated any action or not?
But what they are doing, what they're visiting our shop, and again and again they are just forcing us to vacate the shop in a verbally manner.
When they take a step, then you can come. Even 30 days.
Not good. But we are ready to cooperate in doing things touching the law.
Respondent number 3 is directed to take decision on P1 within 30 days.
Thank you.
No opinion on merit.
Well, the window is part of this, whatever it should be. Has been part of the two of the property, this is no matter, so it's the community will be in the family. See, I directed on the relative function of the impacts. So that is the function of right order of account has been, but the function is set aside for the. This order was very commission of the provision was studied.
Revision is filed by respondent. Issue notice period 7 days, 4 weeks till next date of hearing. Parties are directed to maintain status quo as obtained today.
To explain how we private sector who was also my political rival. The complaint was initiated stating that my certificate of receipt was stored. Inquiry was conducted by the high level committee. That is at P11. So I have presented the document that my father was issued the ST certificate in the year 1978. I have my date of birth certificate from the authorities stating that I belong to Beldar community from and to birth at Seoul. Still, they did not comply with the directives of the Madhuri party. We from 1321 to 10. They have cancelled my certificate.
82, 83, yes. ये जो 1950 के जो डॉक्यूमेंट डिमांड करते हैं, इस पे तो खुद ही गवर्नमेंट का सर्कुलर की कैन नॉट डिमांड दिस सर्कुलर्स हैव नॉट बीन ब्रॉट टू द नोटिस ऑफ दिस हाई पावर. Now cross 12 और 12th के प्रशंसा पत्र में is contended by counsel for the petitioner that the past scrutiny committee constituted in terms of the directions of the apex court in the case of Madhuri Patil has passed the impugned order dated 12/6/2026, which has been passed at the behest of the private respondent, who had contested the election against the present petitioner and lost as well. Because counsel contended वो सर्कुलर लाए कि 1950 के डॉक्यूमेंट पेश करने के लिए आपको कंपेल नहीं कर सकते. It's contended by the council that but there are circular by the state government which stipulates that a person cannot be compelled to produce the document pertaining to the year 1950 while considering the question of issuance of caste certificate. Yet, on that ground only, the order has been passed. Issue notice PF 7 days, returnable 3 weeks. Still not date of hearing effect on operation of impugned order P11 dated so and so shall remain a state. वही सेम ऑर्डर P2 उसमें वो चेंज करके दीजिए. हाँ दे दीजिए. सेम ऑर्डर होगा, नंबर रजिस्ट्रेशन नंबर होगा, रूट बदले. उनको बता दीजिए पांडे चेंज करके दीजिए. ऑर्डर देना बता देंगे. हाँ. Council content petition is rendered in structure. The same stands dismissed having rendered it. Next, उनका नाम respondent. अगला बोलो. अपने फाइल की. हाँ.
Almost for 27, I think. No, that's to how they are dealing with the issue of delay, which they might have done. And that's the visible person with them. You have to provide a point.
And the request of petitioner is the matter day after tomorrow. Next week.
Yes,
Next week, but place the matter in the next week. पास हुआ. पास. हाँ 28 बताइए. बोलिए.
ग्वालियर में तो 95% विकलांग को तो उसमें आप लोग ग्वालियर भेजा था और वहाँ पर मतलब मीटिंग करी है जिसमें अटेंडर को भी साथ में लेके जाना बोला गया है कि कोर्ट की ऑर्डर होने से मंथली उपचार हेतु भेजा जाए और बिना अटेंडर होने शामी का अभी तो नाटक पालन
बताइए.
directly have to take instruction, but that order is ready to Guardian.
हाँ.
And I was informed by the superintendent that hospital is not very mental health. With very change Even if it is for 21 months. That process by the year just section of awareness to keep regulation of vertical exactly. But here they are तो वहाँ कैसे जाएंगे तो सर्च कर देंगे
तो भर्ती कराई
जो ना पानी का एक नंबर ही उसके पास बन जाता उनका
जो स्टार्टअप टेक्निकल है वो अभी है
वही फॉलो होगा
मेट्रो हॉस्पिटल में किसी को रखा नहीं जाता है
वो ट्रीटमेंट जरूर कर देंगे उतना भर्ती करके वो तो कह ही रहे हैं
ट्रीटमेंट हो रहा है तो एक बंदा उनके साथ रहे
अब ये कैसे पॉसिबल वो कैसे भी हो सकते हैं कहीं वायलेंट बिहेवियर भी करते हैं उनको रहना पड़ेगा किसी ना किसी को कैसे छोड़ देंगे आपके घर की तो है वो लिबर्टी आप दे देते हैं whenever आप अपीयर वहां पे होंगे वो भर्ती कर लें ट्रीटमेंट के लिए एज पर इंस्ट्रक्शन यस मिस्टर केकरे
है वो ओनर के साथ मतलब मदर फादर के साथ में और हमारा ये कहना है कि मदर फादर को छोड़ के सिंगल उसको
ये कैसे संभव है
और फिर टाइम के लिए रोका हुआ नहीं क्योंकि बात आता है कि कारण को और यार ओनली वेटिंग फॉर द फाइनल स्टार्ट
क्योंकि वो ऑल टाइम टू कम भी दे विल नॉट कीप हिम इन द हॉस्पिटल उतने दिन के लिए the petition is filed by the respondent for a direction to the respondent to admit from the order to mental hospital / Agra on permanent basis. Shri Kekre submit that he has sought instructions and as per the instructions from the patient cannot be permanently hospitalized. At the most he can be admitted in the hospital. Gwalior for the treatment. It is contended by the council that after the hospitalization, as per the required hospitalization form, the patients are discharged by the hospital and therefore it is for the petitioner to take care of the patient. It is also contended by Shri Kekre that the instructions have been sought which has been uploaded in ERP software. It is contended by the counsel for petitioner that the petitioner are finding it difficult to take care of the patient and therefore their care is it shouldn't be kept in the hospital on a permanent basis. Considering the aforesaid the present petition, considering the aforesaid the present petition stands disposal of the direction to respondent number 3 to ensure proper treatment to the patient, namely so Brahmdut and and ensure proper treatment as well as care during his hospitalization. In the hospital, irrespective of the period, during the period for which he is to be hospitalized. It is also directed that the further that cooperation and assistance will be made available to the petitioner during the course of treatment of the patient in the hospital with the aforesaid observations from the present petition stands disposal. Next week. T11 was the relocation, that's what we have to say. The order that was decided by the economy. In fact, what they allege that you've been permitted was refused to one Diksha Parlor, wherein three connections are mentioned. And despite of giving notice, they are demanding payment over the bill. But order itself deals with this kind of loading. Three levels, my order may have 1.3. तो 12 जनाब 18-12-21 में याचिका करता निर्देश द्वारा के नाम पर एनओसी जारी की गई तो भी सही है उस जनाब से संबंधित विद्युत कनेक्शन कोई भी बकाया राशि चेंज नहीं हुई तथा उस समय में जारी एनओसी सही पाई गई। इसी कक्षा 6/6/2022 को श्रीमती उषा बारक के नाम से एनओसी जारी की गई थी जबकि विभागीय अभिलेखित परीक्षण से स्पष्ट हुआ कि संबंधित विद्युत कनेक्शनों में विद्युत कनेक्शन किसी कनेक्शन का नाम उषा बारक नहीं था। कार्यालय रिपोर्ट के अनुसार संबंधित विद्युत कनेक्शन लास्ट 12863 जिसका मैसेज अनुपमा और उद्योग ट्रेडर्स के नाम से पंजीकृत है जिसमें 2022 की स्थिति में 1600 अमाउंट है। File reply then. Any query submit. Press one granted to the extent to file wakalatnama as well as reply. This is the matter week commencing 13th of July. हाँ ये बताइए इसमें इंस्ट्रक्शंस जो है for the state again press for time to take instructions use the matter on 6th of July. It is made clear that if the instructions are not sought by the negative system, prayer for interim relief shall be considered. आपने केवेट लगाया आपको कॉपी मिल गया
application है पूरा original order of mutation was passed on 6 2009 by the Procedural. And he has been filed in 4/7/2022. Without this, we could formal application of not be
Commissioner has dismissed your appeal.
Sending the order of
Where is that SDO's order?
the order
P2.
P2. Page number 21 more. Funding from is 25. 24. I think that वो किसकी बात ये रिवीजन मतलब वेस्टिज है वेस्टेड बात मतलब दैट नॉट नथिंग दैट डिसाइड दैट आपके
The order of Tehsildar of 2009 was assailed before SDO.
Yes.
In appeal.
In a bit.
And by which order the delay was condoned?
No, there is no application. Single which we have good deal. And no to not.
नहीं कहाँ आपने पिटीशन में कहाँ लिखा कि डिले वाज नॉट कंडोन देयर इज नो ऑर्डर ऑन आपने प्लीडिंग में है सर कौन सा पैरा में बताइए पैरा 5.13 यस बताइए
regarding the partition of the system. The delay application is properly considered by the SDO concerned and passed the order thereafter regarding them. My lord, to consider this fact, in charge the regard of the court of the SDO, all these facts will be reported. Because there, very appreciate para 4 में see all the facts considered by the SDO. He is application and seeking the partition and the reporting are more than 20% in the application. Nobody appeared with mark appeared.
That's different on merit, but whether SDU condone this delay or not.
You condone the delay.
बोला ही उसका रिकॉर्ड बुला ले.
They made deal.
Original partition as per order was requested with the as well as 20% partner. Appeal has been preferred by one appeal partner. And he has participated in the or he has put his signature over the order sheet of the Tahsildar. I filed for
वो जो ओरिजिनल ऑर्डर था तहसीलदार का, it was under section 178. Is intended by counsel for petitioner that an order of Tahsildar passed way back on 6/6/2009 in purported exercise of powers conferred under section 178 of MP Land Revenue Code, has been set aside by subdivisional officer by order dated 21/3/2025 P2 without condoning the delay. It is contended by the council that there was no application for condonation of delay. And without condoning the delay, the power, appellate power under section 44 of MPLRC could not have been exercised. However, this aspect has escaped the attention of the commissioner also while deciding the commissioner ने क्या revision appeal है, भी appeal है, deciding the appeal white P3. The sponsor has entered appearance on behalf of Curator / respondent number 5 and 20. किसके लिए यहाँ? Respondent number 5 and respondent number 20. 20. 40. Submit that. There was an application before subdivisional officer and the said application was already decided by an interlocutory order. And later on, the matter was finally decided. As there are specific pleading in paragraph 5.13 of the writ petition that there was no application for condonation of delay and the appeal was entertained on merit without condoning the delay, it would be conducive to peruse the records of the case which was filed before the subdivisional officer. Take उसमें issue notice to the respondents. We have 7 days returnable 4 weeks, let record of case number 90/appeal/22-23 within bracket Vishnu Bahadur Singh versus Laldi. बहादुर सिंह विष्णु उनके बाद में अलार आ गए थे उसमें वैजंती भाई वर्सेस लाल सिंह. The acquisition by the next date of listing, former parties are directed to maintain status quo till next date of listing. Let the matter be commencing 27th of July. 27 week.
Necessary. Under what condition the patient came to our hospital? That means I think because she was referred by the railway hospital in Jabalpur. And you are watching the kind of page kind of
Page
Still go to the compliment for one. I'm not making myself. Each party. We found that my complaint. I don't come to this 10 of the
page 10.
Page 10. 1 minute. In Karate, please. I have a saying. The entire referral that taken at the railway from where the patient came to. She was engaged with cancer patient at terminal stage of the cancer. And this reads, she was ACO of IND for which she was taking inhalers on and off oxygen support, NPOT, in 2023 she developed skin change over left upper limb
which was assessed by the physician at WCR State Jabalpur. Skin biopsy was done as malignancy. Expert treating doctor then was referred to bipolar central hospital, central railway treated as at Tata Memorial Hospital, Madras. Diagnostic as advanced carcinoma left breast with skin mets chemotherapy. Multiple cycles were given since February 2024 to August first week of 2024. He was under regular follow-up at City Hospital, Jabalpur for chemotherapy and treatment. Also, SEO so as per the treating onco-surgeon at CA Jabalpur. Patient was stating multiple cycles of skin left breast and are diagnosed stage 4 clear breast and also taking various consultations from various hospitals for breast cancer, Tata Memorial, Mumbai, Procedural, Nagpur, Lakshmi Narayan, Jabalpur. Finally, started on treatment by Tata Memorial Hospital, Mumbai. Record share with patient, but the disease was progressive and under metronormic chemotherapy. Also, patient was under follow-up from Dr. Roshni, oncologist at Mandalay during follow-up visit.
So Sangi, you are agreed by which why this petition is filed? Some complaint is being inquired into. What is P9?
P8 is the employer. By P8 at page 221. Your Lordship would found that the comment number 2 collector Jabalpur, he has found the comment. This reads, विधायक सरकार श्री मनोज महावर द्वारा उनकी दिवंगत माता श्रीमती शांति देवी के प्रकरण में चिकित्सा अभिलेखों में संभावित हेरफेर उपचार प्रबंधन में कथित लापरवाही अभिलेखों के संभावित वर्गीकरण हेरफेर तथ्यों के दबाव छिपाव एवं साक्ष्य नष्ट करने के आरोपों के संबंध में अभव हस्ताक्षर करता ये समझ शिकायत प्रस्तुत की गई। शिकायतकर्ता द्वारा प्रस्तुत शिकायत में लगाए गए आरोपों के दृष्टिगत विस्तृत जांच हेतु निम्नानुसार जांच दल का गठन किया जाए। नाम एसडीएम, पुलिस अधीक्षक, जिला स्वास्थ्य अधिकारी, सिविल सर्जन, जिला नोडल अधिकारी, सहायक संचालक लोक स्वास्थ्य, जिला सूचना प्रौद्योगिकी। These 7 persons are the members. Now, what if collector has any jurisdiction? Is there any statutory power in the collector to form this committee? Particularly in the background of P3, that's the family receiving at page 49. It will start from 47. At page 47, this election police.
What
In
is,
this,
wait. This
No,
page
this
2, this order of inquiry by collector,
yes,
that is not qua medical negligence. The issue which are to be inquired into, please read those issue again. समिति निम्न बिंदुओं की जांच करेगी। वो बिंदु है क्या क्या?
जो ऑलरेडी दिवंगत श्रीमती शांति देवी की चिकित्सा अभिलेखों में हेरफेर, वर्गीकरण, संशोधन या प्रतिस्थापन की संभावना, मूल अभिलेखों का संभावित निष्टीकरण, छुपाव या दबाव। Now your lordship may kindly come to annexure P2, that is the report of the committee, expert medical committee, who was formed by the Dean Medical College at the instance of CMHU Jabalpur, where the respondent number 6 made a complaint. And this report is dated 30th January 2025 at page 47. I mean, what this report says, जांच समिति द्वारा विषय एवं जांच समिति द्वारा विषय एवं प्रकरण से संबंधित समस्त पक्षों को चिकित्सकीय दल, रेलवे हॉस्पिटल जबलपुर, मार्बल सिटी हॉस्पिटल एवं शिकायतकर्ता श्री मनोज कुमार महावर को उनसे प्रकरण के संबंध में व्यक्तिगत रूप से उपस्थित होकर अपने पक्ष को प्रस्तुत करने का नियमानुसार अवसर प्रदान किया गया, जिसमें वर्णित चिकित्सकीय दल एवं शिकायतकर्ता में से जांच समिति को निम्नलिखित दस्तावेज प्रमाण प्राप्त हुए हैं। Now from रेलवे हॉस्पिटल जबलपुर के चिकित्सकीय दल द्वारा जांच समिति को उपलब्ध कराए गए मरीज के पूर्ण इलाज की समरी मेडिकल जीएचटी बेडर टिकट दस्तावेज दिनांक 4/12/24 की सत्यापित प्रतिकूल पृष्ठ संख्या 7
मार्बल सिटी हॉस्पिटल जबलपुर की चिकित्सकीय दल द्वारा उपलब्ध कराए गए मरीज की पूर्ण इलाज की समरी मेडिकल जीएचटी दस्तावेज दिनांक 19/12/24 की सत्यापित प्रति कुल पृष्ठ संख्या 52। मार्बल सिटी हॉस्पिटल जबलपुर के चिकित्सकीय दल एवं ड्यूटी स्टाफ द्वारा उपलब्ध कराए गए कथन दस्तावेज दिनांक 3/1/25 की सत्यापित प्रति शिकायतकर्ता श्री मनोज मावत द्वारा प्रस्तुत दस्तावेजों संख्या दिनांक 21 की सत्यापित प्रति। Now, here the statement, oral statements were also taken by the committee. Now, I'm not going to come to clarity of the next week. माननीय गठित जांच समिति द्वारा आपकी आपको विनम्रता पूर्वक अवगत कराया जा रहा है कि स्पष्ट रूप से जांच समिति द्वारा प्रकरण से संबंधित सभी पक्षों को अपना प्रमाण एवं अभिमत प्रस्तुत करने हेतु पूर्ण अवसर प्रदान किया गया है, जिसमें जांच समिति को प्रकरण में वर्णित संबंधित मरीज की इलाज के समय घटनाक्रम से संबंधित किसी भी पक्ष द्वारा सीसीटीवी रिकॉर्डिंग इत्यादि एवं मरीज के शव परीक्षण रिपोर्ट उपलब्ध नहीं कराई गई है, बिकॉज नो पोस्टमार्टम वाज डिमांडेड बाय द अटेंडेंट ऑफ द केस। अतः प्राप्त उपरोक्त प्रमाणित दस्तावेजों के आधार पर जांच समिति सदस्यों द्वारा अपने अधिकार क्षेत्र के में अवलोकन कर प्रकरण के संबंध में निम्नलिखित विस्तृत अभिमत प्रस्तुत किया जा रहा है। माननीय जांच समिति सदस्यों को रेलवे सेंट्रल हॉस्पिटल जबलपुर के चिकित्सकीय दल द्वारा उपलब्ध कराए गए दस्तावेजों के अनुसार मरीज द्वारा पूर्व में मार्बल सिटी हॉस्पिटल जबलपुर में इलाज किए जाने एवं वर्तमान में मरीज को विषय विशेषज्ञ चिकित्सकों की पुनः सलाह थी एक मरीज की इलाज में उक्त हॉस्पिटल में आईसीयू फैसिलिटी इत्यादि उपलब्ध न होने की दशा में मरीज की गंभीर स्वास्थ्य स्थिति को देखते हुए मार्बल सिटी हॉस्पिटल जबलपुर में रेफर किया जाना और भावनापूर्ण दर्शित नहीं होता। माननीय मार्बल सिटी हॉस्पिटल जबलपुर के चिकित्सकीय दल एवं ड्यूटी स्टाफ के द्वारा उपलब्ध कराए गए प्रमाण दस्तावेजों एवं कथनों के अवलोकन से दर्शित है कि मरीज के इलाज से संबंधित आवश्यक उपचार उक्त मौजूदा सुविधाओं में मरीज के परिजनों की सहमति के अनुसार उपलब्ध कराया गया है। Now, all this bed head ticket, that is the only document for which therefore की बात कही गई है उस इलेक्शन की। बेड हेड टिकट हमने पूरी उपलब्ध करा दी, सेंट्रल रेलवे हॉस्पिटल की बेड हेड टिकट आ गई। अब हमने कौन सा डॉक्यूमेंट छुपाया है? दूसरी चीज, ये एक्सपर्ट कमेटी ने इसके बारे में इंक्वायरी कर दी और इंक्वायरी रिपोर्ट उनकी है। माननीय, यहाँ आपको विनम्रता पूर्वक अवगत कराया जा रहा है कि संलग्न शिकायतकर्ता द्वारा प्रस्तुत शिकायत पत्र एवं अन्य उपलब्ध कराए गए दस्तावेजों के अन्य बिंदुओं पर गठित जांच समिति सदस्यों द्वारा जांच किया जाना उनके अधिकार क्षेत्र में नहीं। So now, which was only medical documents which were to be inquired in. Whether ticket is the main document of the patient that we have produced. The test X-ray and all those X-rays and other medical reports, they were also made available to the inquiry committee.
What prejudice is being caused to you by this inquiry?
Not my prejudice is, this is the first report. Now the second is, P3 may kindly be seen. Complaint to state medical council. Next, document.
Yes.
This is made by on the same set of facts, not otherwise. Now, this P3 is running into several pages. Pursuant to this, annexure P4 was issued to me by the MP State Medical Council, OPAC. Now, this MP State Medical Council, is a statutory body constituted under Ayurveda Parishad Adhiniyam 1987. Now, they have issued this notice to me, annexure P4 at page 63. परिषद द्वारा एलोपैथी चिकित्सकों के चिकित्सा व्यवसाय में अमर्यादित आचरण, व्यवसाय दुराचरण अथवा चिकित्सकीय लापरवाही के संबंध में प्राप्त शिकायत प्रकरणों की जांच एवं कार्यवाही इंडियन मेडिकल काउंसिल प्रोफेशनल कंडक्ट एटिकेट एंड इट्स रेगुलेशंस 2002 के अंतर्गत की जाती है। विषयांकित प्रकरण में शिकायतकर्ता श्री मनोज कुमार महावर द्वारा आपके बच्चे शिकायत की गई है। उनकी माता की स्वर्गीय श्रीमती शांति देवी उपचार में आपके द्वारा लापरवाही की गई। अतः श्री मनोज कुमार महावर से प्राप्त शिकायत पत्र एवं उपचार के अभिलेखों की छायाप्रति संलग्न कर आपको निर्देशित किया जाता है कि कार्यदर्शी सूचना पत्र प्राप्ति के 15 दिवस की समयावधि में अपना बिंदुवार स्पष्टीकरण बचाव के समर्थन में अभिलेख
एवं आपके द्वारा पारित शिक्षा अभिप्राय एवं पंजीयन प्रमाण पत्र की सब सत्यापित छाया प्रतियां 2 प्रतियां आदि सदस्य हस्ताक्षर का now the same complaint is there that there is a hierarchy in the documents and all that. Now on the basis of this notice we have already submitted our reply. The matter is now circulated before the MP State Medical Council Bhopal under the Adhiniyam of 1987. This body is a quasi-judicial body having a right to give punishment, impose punishment. Now, my lord, may kindly come to election. P5. P6. And page 204.
Yeah.
Now, my lord, this is a petition filed by the complainant, Manoj Kumar Mahavat, who is respondent number 6 in my petition. This is WP number 21219. Now, your lordship may kindly see. There was in this petition at 214. Para 7.1 that petitioner humbly and respectfully prayed to the honorable court may you please issue it of certiorari by questioning the orders reports dated 10/25 and 30/25 given by respondent number 5 in the interest of justice. That the petitioner humbly and respectfully prayed to the honorable court may you please issue it of relevance directing the respondent number 1 to 5 to constitute independent committee as per the judgment of Judge please to issue a writ of mandamus or direction in the nature of mandamus directing the respondent number 1 for constitution of a fresh multidisciplinary committee with members from medical education department.
This petition is pending.
This petition is pending.
The last rate of it, that was the reason the matter was exempt for today. This matter has been made with my matter and it's there at 32.1. This petition is pending. Now, number 1, before the high power committee. Number 2, before the police. Number 3, before the NPMC. Number 5, before the honorable court. And number 6, before district court. And number 7, before the collector. Now, seven stages we are facing the inquiry. Same point, same number.
Now, my lord, may kindly come to election 230. That is at page 253.
Mr. Sanghi,
My lord.
this petition is by who all are petitioners?
Pardon me?
Who all are petitioners? This one is hospital,
Yes, please.
2, 3, 4 doctor, nurses, right?
Again,
wait,
all
wait.
those persons
Wait,
to whom the
now-
notice has been issued by the inquiry committee of the state
Are,
collector.
please come to the affidavit which has been sworn in support of the petition. This is by only one of the petitioner, whether he is authorized by the other petitioner. Who has authorized him to file this petition on behalf of the hospital? This petitioner is only one of the petitioner. No typography. This is not typographical error. There is no authorization in favor of by the hospital. There has to be a proper affidavit.
To file that authorization and affidavits of other petitioners.
File proper.
Number 1, even if the person who is given the affidavit, Dr. Sanjay Nagaraj, who is the deponent in the affidavit, even for him, the relief may kindly be seen.
Then you don't press relief for remaining petitioner today.
I also press.
Then you amend it. This is a petition in which, the cause title reflect that an array of petitioner. There is one hospital. There are 2 doctors, 2 nurses. However, the petition is supported by affidavit of only one of the petitioner. It is not mentioned in the said affidavit that the person who has sworn in affidavit, has been authorized by the remaining petitioner to file this petition on their behalf. There is no authorization on behalf of the hospital, that is petitioner number 1, in favor of the person who has filed the petition. Counsel for petitioner prays for and to file a proper affidavit. So clear.
On 6th of July,
List on 6th of July.
I'll file it.
Yes.
The petition is not for 43 years. The lease of land granted by the Western Court.
Huh.
There are more than 200 students. None of them just with the income order. 37 which is a paid 130. By a civil line order by police has been determined matter. I have information from
Page number
135.
135.
To order.
Yes. Let notices be issued.
Because to their same, I don't have to vacate the place.
When you vacate it, why? There is no entry
I
value.
have all the permissions for this 200 students, students of 40.
You cannot unauthorized occupy the premise.
I don't have a lease in market, but at least.
That is over. That is already over.
Have a look at the judgment which I have uploaded in yesterday.
Yes.
That is judgment of 1989. Remain the same. State of UP versus Leeds in Maroc. 1989 to 65.
Yes.
That's right.
No, right.
Section serial number 2.
Yes. Okay.
Number 30. Page number 516. Any money.
No, yes.
A lesson with the best of the title has no right to resume possession extrajudicially by use of force from a lessee even after the expiry or earlier termination of the lease by forfeiture or otherwise. The use of the expression reentry in the lease does not authorize extrajudicial methods to resume possession. Under law, the possession of a lessee even after expiry or in earlier termination is judicial possession and forceful disposition is prohibited. A lessee cannot be dispossessed otherwise than in due course of law. In the present case, the fact that the lesser given state does not place it in any higher or better position. On the contrary, it is under an additional inhibition stemming from the requirement that all actions of the government and governmental authorities should have a legal effect. Now, madam, this due process of law, your lordship, the Supreme Court has also considered another judgment which I have taken, which is my lord's express instruction, para 85 of it. There is no indication against me, nothing. They have given these 18 other schools, all schools are broken. It's just that
You come to the previous order passed by this court, page number 126. The page P30. Come to paragraph 5.
This was my lord, I just like my lord, the brother of the secretary of the society was an employee of WC. He was occupying in water. So this water has been located at filed those documents. The collusion petition was filed challenging that order and this seeking the continuation of. My lord, may see I have all the permissions from the state government, even the WC has written to the state government to grant the ownership. It is just because the lordship may just in 35 and be 34 for them. He 35 management. This land is owned by central government. So the state government is pressurizing WCL to determine. And therefore my lease has been given. I find a list of all the schools which are there of the WCL land, who lease have been discontinued, no matter they are still going.
Why that petition was filed? Sealing what? Previous petition, what was challenged? What was
Notices which are issued to the petitioner.
regarding that quarter or the entire land?
That Manoj, quarter is at a different place. This is at a different place.
So petition was pertaining to quarter or
Both.
this land? To file. List this case along with the said petition
Manoj,
records.
that petition is
List this case along with the records of WP number 29472 of 24. Day after tomorrow.
Manoj, till then it's like this.
There is no problem.
Manoj, there are more than this is 40 years old school. There are 200, more than 200.
Okay, you have certain expertise to unauthorously occupy the premises. You occupied these water also, and the court had to direct to you to vacate that.
Water, Manoj, what was the employee
No,
was given by water as a WC.
where it's rejected.
Manoj, the scheme will be close to 200 students would be out.
You are an authorized. The lease was in 83.
So my God, that they have continued, I have continued to write it. My God, they will not for my God, this is 200 students also.
Day after tomorrow. Tell you next.
So much.
Thirty. Sorry. 35. 4. None for the petitioner is the matter in the next week if no appearance. Last date आया है ना? No appearance, this court may consider dismissal of the. हाँ बोलिए. पास हो गई.
On the
कौन सा ऑर्डर चैलेंज कर? इंप्यून ऑर्डर कहाँ है? पेज नंबर. 47. 27. हाँ ये किस ग्राउंड पे चैलेंज कर रहे हैं? क्या गलत है इसमें? रिकवरी के बजाय अलावा आपको बनाना भी था, जो ठीक कराना था दीवार वो करा दिया. पेज नंबर 49. क्या आपने रिटर्न में क्या बोला?
Students just like they have already taken themselves taking the unnecessary the last paragraph of the that they will prepare the answer in and then the factors will reach the age. Age number 17.
Page number 17 of petition. वो reply is at page number 17 है ना petition का.
17 नॉलेज के बाद दिल से शाला भवन तक ट्रैक्टर जाएगी वैसे ही कार लगा दूंगी we are aware that the original is by them is not up to the mark. Several also they are the much of not trying to value report also.
She was at what? This petitioner was सरपंच at that time. क्या गलत बताइए, ठीक तो है? आपने तो खुद ही मान लिया कि निर्माण करा देंगे. By this petition, the petitioner has called in question the order dated so-and-so prayer was the petitioner. It is contended by the counsel that it is a case where the petitioner has been subjected to double jeopardy. A perusal of the order contained in Annexure P11 dated so-and-so passed by Commissioner Division Hoshangabad revealed that apart from an order of recovery of an amount of rupees 65,431, the direction was issued to the present petitioner, to construct the to carry out the repair of the wall as well as roof of the building. The said work was carried out by the petitioner and therefore there could not have been any recovery of the amount of the petitioner. It is therefore contended that the interim order decision or counter counsel for the state has opposed the where and it is contended that when a notice was issued to the petitioner, the petitioner submitted a reply which is contained in Annexure P2 and a reply is the reply leaves out of doubt that the petitioner herself admitted the lapses and even assured the authorities that the proper constructions work would be carried out. It is contended by the council. The aforesaid said reply of the petitioner now. Leaves no other question debatable and the petition dismissed. Having considered the submission perusal of the report, it looks that the commissioner in the interim order has observed that under the Sarv Shiksha Abhiyan, for construction of additional rooms in primary school Jamne Tula Gram Panchayat Kalmeshara, Janpat Panchayat Suhagpur, fund to the team of rupees 411,000 was allocated. This said work was carried out and accordingly, the payments were made. However, it was gathered that against the said work, a payment of rupees 390,450 was transferred in the account of Gram Panchayat and the the valuation of the work was less than the amount which was transferred. Accordingly, the direction was issued to recover the remaining amount from the petitioner. The petitioner, in pursuance of the notice, had appeared before the authority and submitted in the reply that there were lapses in construction work of wall and roof, and even the assure the authority that the proper correction work will be carried out by the petition. In view of the efforts at the commissioner passed the order. The order of the commissioner from since has been passed, taking into consideration the admission of the petitioner herself from, and it is also evident that the amount which was transferred in the account of Gram Panchayat was not fully utilized for the work of construction firm. Therefore, there was no fault in recovery of the remaining amount from the petitioner. Thus, this court does not find any merit in the petition, as the order of the commissioner is proper and is in congruence with the material available before. Next. 37. 37.1. क्या उसमें क्या
We have made some project time another critical for it for the production of product that is going to. So the time wise it will be the common number of commercial area in which factor like common time. Putting over the line of the that will be
and what your case is and what is that connected case? You have to file rejoinder. 37 में कर देना council state is granted 3 weeks time to file return. Place the matter after 3 weeks. 37.1 में कर देना petitioner praise fund granted 3 weeks time to file rejoinder. 37 में रिप्लाई है WB 13566 में 37.1 में कि 37 में देखिए कहाँ इसमें भी नहीं है ERP में भी नहीं there is no reply in ERP also. कनेक्टेड में है उसमें नहीं पहले वाले मैटर में नहीं 37 में नहीं है 37.1 में 37 में फाइल करना है 226 ये किसका रिटर्न है ऑलरेडी स्टेट का है ये रिस्पॉन्डेंट नंबर 226 का रिटर्न एक तो है सबमिशन ऑन बिहाफ ऑफ 226 ये आप ही का रिस्पॉन्डेंट नंबर 226 मींस स्टेट इसकी कॉपी है आपके पास इसको ERP पे भी नहीं है ऐसा करनी ऊपर वाले काउंसिल फॉर द स्टेट इज डायरेक्टेड टू सप्लाई कॉपी ऑफ रिटर्न टू द काउंसिल फॉर petitioner along with enclosures within 3 working days. Office is also directed to upload the return along with enclosures in ERP software of ERP software in this matter after 3 weeks. तो दूसरे में रिजेंडर करो
This might not happen in the notice for responding first. Will be amount for the 2,85,000 from the related to the but not with a minor
I don't think order to be like a free food now. Because we will implement the bank for the so that's part of it.
Who appears for respondent? Respondent कौन? State again.
That's part of it.
तो फाइनल बिल आपने सबमिट कब किया था? पेमेंट इसमें आपको ये बताना पड़ेगा ना, क्योंकि अलग अलग डेट पे पेमेंट करी है ना. रिप्रेजेंटेशन दे दीजिए इंटरेस्ट की, वो डिसाइड करिए. It is contended by the counsel for petitioner that though the payments towards the bill of the petitioner has been made as stated by the respondent in the return, however, the interest has not been paid by the respondent, despite the fact that the delay was attributable to the departmental procedure. As the delay was attributable to the department. It is contended by the counsel the petitioner is willing to make representation for payment of interest on the delayed payment, and such eventuality the respondent concerned be directed to take a decision on petitioner demands, considering the aforesaid petition stands to dispose of the direction that if the petitioner makes a representation giving containing prayer for grant of interest on this before किसको देंगे आप respond number 3 को? Three, 15 days from today, he shall take decision within further 60 days. No opinion on merit. Dispose of. Next. I have lost. Not like the matter in the next week. If no variance, this court may be next week. फोर्टी में बताइए. हाँ बताइए क्या. हाँ
तो इस आधार पर कि मशीन अपनी क्या बन सकता है, कैसे
इसमें रिस्पोंडेंट को नोटिस सर्व नहीं हुआ है क्या अभी? देखिए रिस्पोंडेंट को नोटिस सर्व है. 10 को नहीं हुआ. 10 को
और एक सत्र को अटेंडमेंट 7 बचा था कि उसके लिए
रिस्पोंडेंट नंबर 10 रमा को नहीं हुए. वाइफ ऑफ राधा वल्लभ शर्मा.
virtual payments can be exported. Yes, so this is also very exported. Payment of sales.
क्या करना ना आंसर है अवेटेड 7 और 9 को भी नहीं 7 और 9 के लिए तलवाना फ्रेश दीजिए इन दोनों की रिपोर्ट है लेटेस्ट है 29 जून की कल की रिपोर्ट है 7 and 9 को नोटिस नहीं let fresh notices be issued to respondent number 7 and 9 who according to office report are still unserved comma on payment of process fee within 7 days returnable 3 months plus the matter week commencing 3rd of August. Next. None. So the matter in the next week with no appearance this court. Next. None. We use the matter in the next week with no appearance this court may consider dismissal. नहीं पर next week कर देते हैं as spread by petitioner lose the matter in the next week no further delay.
This distribution has rendered ineffective because the order, because the given order which was passed in excellence of that particular solution has already been decided and completed.
Council content petition is rendered infructuous the same starts dismiss having rendered infructuous. Next. Infructuous it may be same but council content infructuous dismiss as a right. Incorrespondent and number. Next. 46.
Not 46. Okay. It's an old matter. After 46 is coming up again, but the management has changed the property divided. In two cases, my lord, they had taken an notice of minority proper they partnership was of that if the stay was initially there, it's all vacated or between always. Like especially I would say, madam.
Even SPC they won't turn now. Even after SPC they won't turn now. Or you can make an effort to contact them. Let's next week run
ये सोसाइटी का इसमें मैनेजमेंट चेंज होते रहते हैं तो लॉयर्स भी चेंज हो जाते हैं तो इसमें हमको बहुत समय से काफी सारे मैटर्स थे बट आई हैव नॉट रिसीव्ड एनी स्ट्रक्चर्स I would just
It
request
is contained
even
in the
otherwise
council by petitioner that this is a petition by the society and the subsequent office bearers have not contacted the council. You have submitted that SPC vehicle. Let SPC be issued to the respondents with the matter in week commencing. Please July. 20th July. Clear.
My lordship, in this matter, the respondent number 1 reply is awaited, my lordship. I am for the respondent number 2, but I am just trying to abreast your lordship that whatever the respondent number 1 has not filed the reply.
There is no counsel, no representative. Yes. आप ही का 47. अब बोलिए. We are seeking time. Next week.
May I request if my lord have it after 2 weeks, my lordship, so that meanwhile I file some of the documents which required to be filed in this matter.
Let counsel seek instruction whether petitioner is willing to pursue this petition or not.
Grateful.
As prayed by petitioner, list the matter in the next week. No further than that. आपका
Great.
respondent ने हाजिरी लगा दी.
Great.
Next.
What shows you that significant will already been disposed of. 6 months coming back, you want to show the federal to this. In fact, I am not the part of the federal. And the end it was the government funds of 31%. And 5 acres has been allotted for the Yuga. And an acre order has been granted, which provides the entire piece of land. Because sometimes we have asked for the permission from the some events there, but that amount was coming in, right? That's why we have found it. But since the direction was given to the problem of D6, which comes to see, just to clarify as to what is this.
Next week.
Why not? Yes, but it's not vulnerable. And it's still a very late.
अब next week बताने उनको instructions ले लेने दीजिए. Perhaps they won't press it.
And after those who were the parties before the tribunal, they filed a civil division before the sovereignty. This civil division was linked with this writ petition. In that civil division has been dismissed. Now, there is no point if he is as a party over here and was not there as a party, filed a petition number 1 who is going to become as a party over here. Since writ petition is not linked. That is already that's the value and after this petition was filed, one was posted to be changed. But that was not, but that was again not against implemented law, not the final order where I think for that purpose the right to get accepted
ये file देखा.
the article 323 this tribunal is not constituted by this tribunal is constituted by the parliament. Why the act of parliament this tribunal has been committed. And as per the act, there is a remedy of filing a civil division, not the writ. But there are three reasons. One is one question the order to the other change. Another 2013. The other is that
You approach tribunal then.
I'm saying they must see the instruction, they are party before the tribunal. What is the state of before the tribunal? I am aware of the, I am not aware of the status of the case before the tribunal. But it is at the stage of final argument before the tribunal. Evidence has been recorded. It is at the stage of final argument before the tribunal. At any time we would decide.
This petitioner is party before the tribunal. So then you move appropriate application. If you are interested, वो liberty आपको दे देते हैं. Ultimately, you challenge some order which was passed, interlocutory order passed by the tribunal in this petition. In that, in the case in which it is passed, you are not party to that case.
That's what I'm saying. Next week, I'll seek the instruction. That order just came to me, my knowledge, which was part of
The request, मैं कौन बता दीजिए day after tomorrow रख देते हैं. The request of petitioner list the matter day after tomorrow. परसों बताइए. बाकी आपका हाजिरी डाल दीजिए. Day after tomorrow. Non flipping matter in the next week, no appearance this court में consider. अगला नहीं. And for the petitioner on 11/9/2015 also no one appeared. Dismissed for want of prosecution. Shri Saxena for responding. Next. Ordering. Witness ordering. इसमें reply आना. क्या मैटर है? क्या केस है? What's the notice? वहाँ नोटिस कौन सा इम्प्यून नोटिस? पेज नंबर P1. उसमें अभी रिप्लाई नहीं आया. तो लेट this notice was issued. So ultimately, as on date, there is no return. Or let this notice go, Liberty will be there to issue fresh notice if any cause. Because even otherwise, there is an interim order by this court since last 11 years. तो लिबर्टी आपको दे देते हैं कि फिर नोटिस आप दे नहीं आते, अदरवाइज अभी तो इसको पॉश कर देते हैं. This is a petition by which the petitioner has this notice was issued by Gram Punjab. They were KVIT was filed by the erstwhile secretary and Sarpanch of 2015. Now there is no one at all. Really, 2 weeks time is granted to counsel for the state as a last indulgence to file reply. With the matter be commencing 3 July, IR to continue. Next. 52. Infectious हो गया.
Allotment of slot का तो मालूम नहीं है.
काउंसिल तो अभी आपसे टच में नहीं है. Counsel pleads no instruction. Petition is dismissed for want of prosecution. However, petitioner is at liberty to revive prayer if any cause arises. इंस्ट्रक्शंस लिए आपसे? अभी इंस्ट्रक्शन लिए रिसेंटली नहीं लिए. नेक्स्ट वीक रख देते हैं, आप पूछ लीजिए. So that is now virtuous now. लिबर्टी दे देते हैं आपको कि रिवाइव कर लें. Counsel for the state submit that the cause agitated in the petition has rendered infructuous. According in the view of the aforesaid statement, the petition stands dismissed having rendered infructuous. However, petitioner is at liberty to revive prayer if any cause survives. Next week बता दीजिए. Aspirate by petitioner list the matter in the next week. वो पहले प्रेस को करना चाहे पहले इंस्ट्रक्शन नेक्स्ट वीक में देख लूंगी. दिस नेक्स्ट वीक बाकी हाजिरी का हाँ सबकी हाजिरी का अगला 55 हाँ Split by petitioner list the matter in the next week. No further adjournment as the case is pending since 2015 years. वो भी हो गया हो इन्फेक्शियस हो गया है. हाँ तो अगर क्या इंस्ट्रक्शन भी है तो टेन्योर ही ओवर हो. उसको आपको लिबर्टी दे देते हैं कि अगर कोई कॉज हो तो रिवाइव करने पड़ेगा. काउंसिल गिव्स इंस्ट्रक्शन petitioner stands dismissed for want of prosecution. However, petitioner is at liberty to revive prayer if any cause survives. ऐसा कर. ठीक है अगला हाँ
which is the substratum and digitally disposed of. One of that would be require instructions to my client manager for property of the property.
वो peers for petitioner. मुकेश अग्रवाल ब्रिजेंद्र कुमार वैश्य यही वाला है ना. 56 है ना 56 हाँ क्या अच्छा 56 में काउंसिल कंटेंट है पिटीशन एज रेंडेड. अगला बोलो ये वाला है क्या. लास्ट डेट पे आए नेक्स्ट वीक रखते हैं. परहैप्स दे आर नॉट बिकॉज नो वन इज टर्निंग अप. None for the petitioner.
Next few weeks, I would be also better prepared with inspection. The important matter what has happened, my lords, but they have encroached in the green belt of the Kalyasot River. They are now enjoying an important state which has been vacated by a coordinate bench. The important matter.
The interim order has been vacated.
By a coordinate bench in a separate matter.
But in this case, there is some interim order. But in this case, there is some interim order.
It's an interim order which is protected on procedural grounds.
If this matter on 7th of July, none for the petition, this matter on 7th of July. IR, if I need to continue, it is made clear that if there is no appearance on the next date, this court may consider dismissal of petition for want of prosecution. 7th of July. Yes. इनका हाजिरी डाल दो. Mr. Jha for response. स्टेट का रिप्लाई आना है. रिप्लाई देना आप 3 weeks time as a last indulgence to state to file reply list the matter in week commencing 27 July. IR if I need to continue. Next अगला IR to continue. पहले हाँ man list the matter in the next week if no appearance this court may consider dismissal. अगला बताइए. As paid by petitioner, list the matter in the next week. No further than अगला. How much as paid by petitioner, list the matter in the next week. Next week. नो फर्दर देन वो पहले दे इसमें 62 में देखूंगा 62 देखूं पहले आए This is the matter in the next week. No appearance. This court may consider dismissal. Next. Council content petition is rendered infructuous. The same stands dismissed, having rendered infructuous. Next. List in the next week. If no appearance, this court may consider dismissal. Agla. 55. Again. The costume. Ah. Other review? None for the petitioner. Yes. Counsel for the respondent number that the petition has rendered infructuous by crux of time as the resolution was sought in the petition. Conceding the submission, petition stands dismissed, having rendered infructuous. आप लोगों का हाल ही आप for one respond. You voted for number one and the for. $66. Maybe infructuous हो गया. Counsel for the respondent submit that the suit in question has already been decided, out of which the impugn order was arising out. Therefore, petition has rendered infructuous. Conceding this statement, petition stands dismissed, having rendered infructuous. Next. Yes. 67. Infructuous हो गया. Almost कहाँ लिखा? हाँ. Which paragraph? They make a statement when they will make a statement only on the basis of pleading whatever they have pleaded in the written. क्या लिखा? कौन से पैरा में? हाँ तो जिसको उसी के लास्ट पैरा में क्या पढ़ी?
And the state authorities which drop proposed proper scheme. As per my
आप लोग दोनों वेरीफाई कर लीजिए, नेक्स्ट वीक रख देते हैं. अगर ड्रॉप हो गया तो infructuous. आप भी मिस्टर शुक्ला आप भी कंफर्म कर लें ड्रॉप हो गई. Parties praise for time to seek instructions in view of paragraph 11 of the written. List the matter in the next week. No further adjournment. आप भी वेरीफाई कर लीजिए.
For my information, the commissioners are in possession of their land. There's no construction of the land.
अरे वहाँ आप भी एफर्ट कर लें, अथॉरिटी बता देंगे कि ऑलरेडी ड्रॉप हो गई है एक्विजिशन. मिस्टर शुक्ला आप भी बता दें नेक्स्ट वीक. आइडेंटिकल है, उसको भी साथ में रख देते हैं. नेक्स्ट वीक अलॉन्ग विद डब्ल्यूपी स्लिप में लिखवा लो. अगला बोलिए. हाँ 62 में क्या हुआ? नेक्स्ट वीक हुआ. हाँ नेक्स्ट वीक 68 बताइए. हाँ
They have not given the information of time on. They said that the person was not people work because they have not, they have no money. How can they know if the money is there?
किस कौन सा ऑर्डर चैलेंज कर रहे हैं? P1 P1 हाँ। अच्छा, इनका कहना है कि रिकॉर्ड्स ट्रेसेबल नहीं है, नहीं मिल रहे हैं।
ऐसे नहीं, ये भी था है मिलना जो लोग जिनको जिनका तो ज्ञान होगा पड़े वो लोग वो कर दो।
हाँ, उनके ऊपर लिखा ना पैराग्राफ 6 में, संपूर्ण प्रयासों के बावजूद अभिलेख नहीं मिल रहे हैं एवं तत्समय कर्मचारी
इवन लेकिन फ्री टेन दो,
हाँ,
इवन फ्री टेन दो।
तो ये आपने इंस्ट्रक्शंस लिया, स्टिल दे आर विलिंग टू प्रेस दिस पिटीशन और नॉट? आपने अपने क्लाइंट से लिया है? हाँ, तो आप बात कर लीजिए, नेक्स्ट वीक रख देते हैं, आप कॉन्टेक्ट कर लीजिए वेदर इज विलिंग टू प्रेस दिस पिटीशन। काउंसिल फॉर पिटीशनर प्रेस फॉर टाइम टू सीक इंस्ट्रक्शंस फ्रॉम द पिटीशनर, लिस्ट द मैटर इन द नेक्स्ट वीक। तब तक आप पता कर लीजिए वो प्रेस करना चाह रहे हैं। नेक्स्ट पहले आए none for the petitioner, list the matter in the next week. If no appearance, this court may consider dismissal of petition. Next one. Phone number. 17 number 1. 79 70 में पास हुआ कर दी पहले आए 71 देख 71 respondent ने बढ़वा दिया। And for the parties, list the matter in the next week. No appearance, this court may consider dismissal अगला। Yeah. 2 weeks time for rejoinder to petitioner, list the matter in week commencing 20 July, 20th of July. Next, higher penny to continue. Last order taking. Last इसमें देखो, last order on fill. File notification hand. अभी fresh है क्या? Fresh petition. Yes. None for the petitioner list in the next week. Next week. 75. हाँ, चलिए नेक्स्ट वीक रखते हैं इसको। नेक्स्ट वीक देखते हैं अगर वो आ जाता है। None for the petitioner, list the matter in the next week. With no appearance, this court may consider dismissal. Shri Aljaria for respondent. 5. इनका 10 के लिए आप करा अगला बोल। None for petitioner on 18/12/2025. Also, no one appeared, dismissed for want of prosecution. Later on, none. Next week, if no appearance, this court may consider dismissal. Next. The last. 78 for the last one. You are appearing, Mr. Rao? 78. Huh? So it has rendered infructuous.
We have complied that this is much. So we have specifically stated on affidavit this time.
तो भी next week देखते हैं, अभी तो कोई आया नहीं. None for the petitioner, Shri Rawat for respondent, list the matter in the next week. If no appearance on next date, this court may consider dismissal of petition for want of process. Next date की देखिए. Seventy-one. 71 में दोनों की हाजिरी डाल. Next week. वो petitioner नहीं, इनकी respondent में हाजिरी डाल. Yes, 74. Next week के लिए next week. Pass over material. Pass fresh case. 73. नहीं, आप किसके लिए पिटिशनर है रिस्पोंडेंट में? हाँ, तो पिटिशनर के लिए कोई आया नहीं था, नेक्स्ट वीक हुआ है. हाँ, इनका हाजिरी डालो. 70. हाँ, क्या कहना? पिटिशनर के लिए आप पिटिशनर के लिए एट द रिक्वेस्ट ऑफ पिटिशनर लिस्ट द मैटर इन द नेक्स्ट वीक कर दें. उनकी हाजिरी रिस्पोंडेंट में डालो. $26 password. Password.
Yes. 105. The petition directed against the implement order section P7, by which the petitioner who is operating a liquor shop, retail liquor shop, has been directed to shift his shop to some other location. But for the last since the year license year 2023-2024, the liquor shopping is being operated not from the same year. But I'm just supplying a lordship to the chart. Where the lordship would find that's from the same location, not since 2023 and in continuation, it is being operated from the same place. And this land was allotted by the municipal corporation. That's the lordship would say in section P7. What it says, P7 is at page 90. Middle of the page, Lord.
Yes.
P7 at page 90. आपके द्वारा दिनांक 21/6/2026 लॉर्डशिप को
Ah, yes.
ये आपके द्वारा दिनांक 21/6/2026 को प्रस्तुत उत्तर के संदर्भ में कंपोजिट मदरा दुकान पुराना किला के विरुद्ध प्रभारी स्वयं से जांच करवाई गई। उनके द्वारा प्रस्तुत जांच प्रतिवेदन प्रस्तुत तथ्यों माननीय उच्च न्यायालय जबलपुर द्वारा पारित निर्णय दिनांक स्वयं मध्य प्रदेश राजपथ क्रमांक दिनांक 20/2/26 की कंडिका 3.6 और दिस इज इंपॉर्टेंट 3.6 आई रिफर जन विरोध वक्त दुकान के वर्तमान संचालन स्थान को लेकर विभिन्न माध्यमों से शिकायतें प्राप्त शिकायतों को दृष्टिगत रखते हुए प्रकरण पर विधि अनुसार सम्यक विचारोपरांत जिला निष्पादन समिति भोपाल द्वारा नगर निगम भोपाल द्वारा प्रदत्त जारी किसी भी अनुमति आवंटन आदेश के बगैर पॉलिटेक्निक चौराहे के पास नगर निगम भोपाल के स्वामित्व की भूमि पर संचालित हो रही कंपोजिट मदरा दुकान पुराना किला को उसके वर्तमान संचालन स्थल से उसके वर्ष 2026-27 हेतु निर्धारित परिक्षेत्र में अन्यथा आपत्ति रहित स्थल पर स्थानांतरित किए जाने का निर्णय लिया है। Now, Lord, if your lordship would see clause 3.6 is at page 28. I have filed the excise policy also, which is at page 28, 3.6. But this is not applicable at all. मदिरा दुकान के अवस्थापन परिक्षेत्र के अंतर्गत ही उसका स्थल परिवर्तन आवश्यकता होने पर अनुज्ञप्तिधारी फॉर द लाइसेंसी द्वारा वित्तीय वर्ष के प्रथम माह अथवा निष्पादन दिनांक के आगामी 1 माह जो भी अवधि बाद में पूर्ण की अवधि में उस मदिरा दुकान को आवंटित अवस्थापन परिक्षेत्र के अंतर्गत अनुज्ञापन प्राधिकारी को प्रस्तुत पूर्व सूचना के अधीन सामान्य प्रयुक्ति के नियमों की दृष्टि से उपयुक्त स्थल पर दुकान का स्थान परिवर्तन किया जा सकता है। But if I want what is my licensing want to shift the shop to some other location, I can do it with prior information. But this clause would not have been invoked. This gives the liberty to the licensee for shifting of the shop to some other location. If I find some better location, I can shift. Now, Lord, in identical situation, Lord, I just apply a lordship. Lord, the number of orders have been passed by this court, Lord. Putting a lordship as also by.
Where is that order which is passed in writ petition? That impugn order is referring to some order of this court.
Yes.
Or where
The
is
second round of litigation, I filed that order also, Lord. Earlier also the similar order was issued. I was given a liberty to approach the authority, Lord. P5 at page 86. P5 at page 86. The present petition has been filed seeking the following relief. Into the directions given by this court on 12/6/2026, Council appealing for the state on instruction from the State Excise Commissioner Ramesh that they are not taking any courtesy action against the petitioner in pursuant to the notice issued to him for relocation of liquor shop in question. However, it is submitted the matter is to be finally considered and decided by district level committee within a period of 2 months from the date of issuance of license to the petitioner. And in case the committee is not in a position to decide the matter within 2 months, then the matter will be considered by the excise commissioner and the final decision will be taken in accordance with law. Till the final decision is taken by the authority, the functioning of the liquor shop will not be disturbed. Now, Lord, excise commission, considered by the excise commission. And if a lordship puts in the impugn order section P7 is by the collector.
matter is to be finally considered and decided by district level committee?
Yes.
Within so this decision is of district level committee.
But,
P7 at the bottom. जिला निष्पादन समिति द्वारा आदेशित.
Yes.
So where is this decision?
That decision has not been supplied. That is all. This is the only order that it was summed up. This is dated 25/6/26, and we were required to ship in 3 days.
अब 3 दिन में हम इस से कहाँ शिफ्ट कर लेंगे and the area that's specified within the same allocated area we have to shift. And if your lordship puts it, as supplied or not with the orders of this court in identical situation, but the number of orders have been filed, have been passed.
Yes, Mr. Kekre. That previous petition was listed on 15th June. P5 order, page 86.
Yes.
And the statement was made by the government that they were not going to compel the petitioner to shift anywhere else. And the court was apprised of some decision was being taken by the district level committee. And this within 10 days, this comes P7. Page 28.
Or 3.6 has been dead. 3.7 has not been dead.
पढ़िए 3.7 अपरिहार्य परिस्थितियों को
तो डिस्ट्रीब्यूशन करते हुए 2026 में जिला निष्पादन समिति वगैरह होगा बंद करने हेतु सरकारी आयुक्त प्रश्न अनुसार रही निश्चित कर सकेंगे इसमें निर्णय सरकारी और शासन को उनके किया जाए और by getting the economic license follow here find an affidavit the copy of the affidavit color the check go to clause 9 of it. मुझे यह ज्ञात है कि अभी दुकान में पूरे विभाग में क्षेत्र ऑफिस की रीच को खोजकर वहाँ दुकान काफी के संचालित करने का दायित्व मेरा स्वयं का है। Now let's see this lecture P7 20.6 under P7 संबोधित रखना दुकान खाना पीना के वर्तमान चालक स्तर को लेकर जांचकर जन विरोध पर विभिन्न लाभनी प्राप्त शिकायतें कायम करते हुए 2026 प्रभावित नौकरी लक्ष्य दिनांक 24 से 26 आपको दिनांक 21 से 25 माध्यम they have already filed an representation for the excise commission. That is the right of freedom. And paid 110.
One 110.
पुराना किला को वर्तमान संचार तो हटाए जाने के संबंध में भारत में completely ignored by me. That is submitted of 20/6, 12/26.
बट मिस्टर केकरे अगर आप 3.7 पे आर्ग्यू कर रहे हैं क्लॉज तो 3.7 देन दिस डिस्ट्रिक्ट कमेटी कैन ओनली रिकमेंड कैन नॉट टेक एनी डिसीजन अगर आप 3.7 पे यू आर रिलाइंग ऑन 3.7 यू रीड दैट yes
3.7
Not by submitting 3.7, they have read their language. It only provides a closure of the form, not for shifting. And 3.6 not has no application at all. Now, if a lordship puts it, I just not kindly see page 109, my lord. It is an election period. There is a letter of the State Excise Commission, P11, dated 22/5/2026 for the current license year. And similar letters were written by the State Excise every year, not I just read it उपरोक्त निशांतर्गत संदर्भ पत्र भोपाल जिले की 5 कंपोजिट मदिरा दुकानों को वर्ष 25-26 हेतु आपके संदर्भित कार्य पत्र द्वारा भूमि दुकान का आवंटन तालिका क्रमांक 7 के अनुसार किया गया। वर्ष 26-27 हेतु उक्त कंपोजिट मदिरा दुकानों के अनुज्ञप्ति का आवंटन निम्नानुसार तालिका क्रमांक 5 में अंकित लाइसेंसी को किए जाने का विवरण है। नाउ सीरियल नंबर 4 बुलाने का लॉट the land development corporation, well, overnight it would not become an objectionable area. The External Excise Commissioner itself is writing a letter to the corporation for forbidding the license to run his shop from the same place. I'm not, if your lordship would see 3.8, just take a kindly see 3.8 also. At same page, but page 28. Page 28.
ये
जिला निष्पादन समिति द्वारा निर्धारित स्थान, जिला निष्पादन समिति में निर्धारित स्थान पर नगर निगम और नगरीय निकाय द्वारा मदिरा दुकान के संचालन हेतु दुकान उपलब्ध कराई जाने पर उक्त दुकान में मदिरा दुकान खोलने की अनिवार्यता रहेगी, किंतु यह सुनिश्चित किया जाए कि नवी मदिरा दुकान का क्षेत्रफल पूर्व संचालित मदिरा दुकान से कम ना हो। वहीं पे 2023 से चल रही सेम प्लेस एंड एवरी ईयर म्युनिसिपल कॉर्पोरेशन इज रियलाइजिंग लाइसेंस की ऑन per month. This is not any day shop is being run.
नहीं तो उन्होंने they have earmarked some place where it is to be shifted.
They have not earmarked any place. Now within the area, the overall area, what I have to shift the shop to some other non-objectionable area.
As per 3.8,
Yes.
they will even identify that shop where you
yes,
to be shifted.
exactly.
And therefore it says that the area of that shop should not be lesser than the area which was already.
Yes, yes.
तो ये जो इम्प्यून ऑर्डर में ये आपको उन्होंने बताया कि आप कहाँ शिफ्ट होंगे, ये कैसे होगा मिस्टर केकरे? या तो ये भी बताएं कि ए से जाके ए स्थान से जाके आप बी पे चले जाइए। मतलब उन्होंने कहा कि अन्यत्र ले जाए, तो अन्यत्र बताएं तो, क्योंकि हो सकता है दूसरी जगह भी ऑब्जेक्शन आ जाए।
ये हाईकोर्ट का एक ऑर्डर है, उसमें लिखा है,
मतलब या तो ये बोले कि यहाँ से हटा के आप वहां चलाएं तो भी समझ में आता है कि यहाँ पे ऑब्जेक्शन।
कोई भी ऑब्जेक्शनेबल एरिया, कोई भी नॉन ऑब्जेक्शनेबल एरिया मिलेगा ही, कहीं भी दुकान खोलेंगे कुछ ना कुछ ऑब्जेक्शन तो आ ही जाए। But this is what the High Court has written in one of the cases. आप ही ने बोला यहाँ खोलिए।
ये वेट ये क्या कहलाता है? डिस्ट्रिक्ट कौन सी कमेटी है ये? डिस्ट्रिक्ट
निष्पादन कमेटी, जिला निष्पादन कमेटी।
इसको क्या बोलते हैं? डिस्ट्रिक्ट एग्जीक्यूशन कमेटी और डिस्ट्रिक्ट लेवल कमेटी। तो इसका जो डिसीजन है वो यू फाइल इट, बिकॉज अल्टीमेटली उससे क्लैरिफाई होगा कि व्हाट वाज, बिकॉज ऑन 15 perusal of the record reflect that the previous petition was filed before this court by petitioner by WP 19928 of 26. The same came up for consideration before this court on 15th of June 26. A statement was made by counsel for the state that no coercive steps was to be taken against the petitioner pursuant to the notice dated 3/6/2026, and it was also, and the court was also apprised of that the matter would be considered by district level committee within a period of 2 months, and in case the committee is not in a position to decide the controversy, the matter shall be decided by the excise commissioner. Accordingly, in view of the statement made by the counsel for state, this court disposed of the petition while order dated 15th of June 26. Stop. After the disposal of the petition, within 10 days, interim order dated 25/6/26 P7 has been passed. Though the interim order contains a reference to the decision taken by the district level committee within bracket district execution committee, but there is no decision on record so as to ascertain the reasons which prevailed upon the committee to take decide shifting of the shop allotted to the present petitioner. Shri Kekre is directed to requisition the entire file, including the decision of district execution committee, pursuant to which the interim order dated 25 से 2026 has been passed. कब बुला लेंगे? कब तक? Place the matter on Friday till next date of hearing. Friday sir, Monday. Monday, list on Monday till next date of hearing. The impugn order P7 will be kept in abeyance.
I did not proper link. I may even get it by.
ये इनको वापस मिस्टर केकर को दे देंगे। ये भी वापस दो।
But 79.
P10
समान वेतन देना चाहिए।
अरे तो ये तो सर्विस मैटर हो गया, दूसरी बेंच का है। दिस इज अ सर्विस मैटर टू बी according service matter. Thus office is directed to list this case before appropriate bench dealing with the service matter as was prevalent roster in the next week.
My lord, kindly see the last order, 1577,
Hmm.
in which the IA was allowed for effecting the substituted service of notice. My lord, kindly take the copy of the newspaper and report.
You are appearing for
Respond number.
1 and 3.
One and some paper necessary to provide.
1 and क्या मैटर क्या है?
They are giving the interest, but Replan has imposed a condition that they have to serve a notice to the non-applicants within 2 days. That condition was not complied with by the claimant because the ex parte award was lost. So on that ground, that since they have not complied the condition, the executing court has dismissed the execution on full satisfaction of the award. 1,90,000 was the awarded amount, and from date of application to date of judgment, there was interest was of 8,500. That was deposited, and on such deposit, the execution petition was
बताइए क्या क्या है?
fully satisfied.
आर्ग्यू करिए।
So, kindly, Mr. Mandel, see the language.
At the request of petitioner, list the matter in the next week. No further agenda. पहले आए लास्ट ऑर्डर है इट क्रिएट टाइम कंडीशन कि पहले वाला दूसरी नोटिस और उसके पहले वाला लास्ट हमारी वाला लास्ट नहीं नोटिस भी नहीं है नोटिस को है For the petitioner to place the matter in the next week if no appearance of this court may consider dismissal. स्टेट को देना
Their rent was required, and compensation was paid, being their family. The land was in the name of their family. Or the land was in the name of their family. They are stating that the compensation has been paid to their family.
and this has already been paid to the family members. तो आपको उनके खिलाफ अरे भाई बट आप यू हैव टू रिकवर इट फ्रॉम देम. अगर आपका कहना कि 1/3 आपको मिलना चाहिए, आपका यही कहना ना 1/3 आपको मिलना चाहिए. दिस हैज ऑलरेडी बीन पेड. आप उनसे क्लेम करें. ये प्रेयर तो यही है ना आपकी 1/3 आपको मिले. तो जिनसे आपका वो लिबर्टी दे देते हैं कि आप उनके खिलाफ सूट लगा लें. आपको दैट लिबर्टी कैन बी रिजर्व विद यू. This is a petition by the petitioner while praying for a direction to the respondent to pay 1/3 compensation to the present petitioner towards acquisition of the land. It is the case of the petitioner that after acquisition of the land, an award has been passed. The land is owned by petitioner, his brother and mother, and they have equal share in the property. However, the compensation has been paid to the other owner and the same has not been paid to the petitioner. Counsel for the state submit that the compensation to the landowners have already been paid. If there exists any interstate dispute between the family members, including the petitioner herein, it is for the petitioner to file a suit for recovery of the amount. Considering the aforesaid submission, considering the aforesaid submission, it is evident from it reflects from the perusal of the record that the petitioner is claiming compensation while asserting his right on the basis of ownership of the property in concern, property in question. It is if the amount of compensation has been paid to four owners, it is for the petitioner to take appropriate proceedings for recovery of the amount. Accordingly, reserving the aforesaid liberty with the present petitioner. When the petition stands disposed of, it is made clear that there is no expression and merit. Next. Then list the matter in the next week, no further.
Filed an application
Yeah.
to the Tehsildar for correction of map and document. Now, that application was, inquiry was conducted by the Tehsildar, and that was forwarded to the collector passed an order for correction of map.
Yeah.
That order was seen by the respondent before the commissioner, claiming that he was not afforded any opportunity of trading. So the commissioner on this ground allowed the appeal and set aside the order. Further,
Who appears for the other side? Mr. Dinesh Kaushal. He's adjusted. Counsel for respondent is reported to be adjusted. List the matter after 2 weeks. I are to continue. Counsel. ये इंस्ट्रक्शंस ले ले, नेक्स्ट वीक बता दीजिए आप। At the request of petitioner, list the matter in the next week, no further adjournment. हाँ
2012 में लाइसेंस कैंसिल किया तो
हाँ council puts no obstruction, petition stand dismissed for want of prosecution. However, petitioner is at liberty to revive prayer if any cause survives. Next. Yes, petition submit that tendered interpretation. Dismissed. Next. Next week, as per by petitioner, list next week, no further adjournment as the case is pending since 2015. अगला आप रिस्पोंडेंट के लिए नेक्स्ट वीक रख लेते हैं, अगर वो नहीं आएंगे तो कर देंगे. नन फॉर द पिटिशनर, लिस्ट द मैटर इन द नेक्स्ट वीक. If no appearance on next date as well, this court may consider dismissal. Next week, उनका रिस्पोंडेंट में नाम डाल. इसमें एडजस्टमेंट है. There is an adjustment note of counsel for petitioner, list the matter in week commencing. Voila.
Name from the police register.
हाँ
Which is the
अरे कनक फाइल counsel for petitioner is reported to be adjusted, list the matter in week commencing 6th of July. Counsel is not there.
supplementary demand on 99 clause of the same. That order had not been challenged.
Yes.
withdrawal to the petitioner able to that give some request.
Counsel for the petitioner prays for withdrawal of the petition with liberty to release within this court if any cause survives or occasions so arise in future. Dismiss as withdrawn with liberties. आपका respondent आए पहले दो लास्ट ऑर्डर देखो. None for the petitioner. Just in the next week, if no appearance, the court may consider dismissal of it.
94.
As prayed by it. You are for respondent. आप तो respondent के लिए हो ना, इसमें आए petitioner पहले देखो. ये 94 खुला है. ब्रिजेश मिश्रा. Next week, none for the petitioner, list the matter in the next week. आपका respondent में डाल दिया. Next week.
95.
95 बताइए. हाँ 95 93। हाँ नेक्स्ट वीक किया है, क्या करना है?
उसमें उसके लिए था लिबर्टी के लिए तो वहाँ से एप्लीकेशन फाइल हुआ था कि विड्रॉ विथ लिबर्टी फेक।
हाँ
तो कोर्ट में फाइल कर दिया, आवेदन अलाउ कर दिया और उसको फाइल ये लिबर्टी नहीं, क्योंकि उसमें किराएदार और उसका वो था तो दोनों।
तो अभी इंस्ट्रक्शंस ले लीजिए, प्रेस कर रहे हैं कि नहीं पिटीशन? अभी आपने रिसेंटली कांटेक्ट हुआ है आपका?
नहीं कॉन्टेक्ट नहीं हुआ, पर उसमें वो तो दोनों मर गए, वो जो वो था मालिक और किराएदार दोनों मर गए।
हाँ।
उनके बारिश उनकी पत्नी और वो आई उनका ये था कि फ्रेश फ्रूट के लिए एप्लीकेशन। विक्रम दिखी बाटी फ्रेश फ्रूट के रूप में इतना
नहीं तो ऑर्डर आपने कौन सा ये वाला? अच्छा आपको लिबर्टी नहीं दी है क्या?
जी लिबर्टी नहीं दिया आवेदन तो विक्रम का दिखाई लिबर्टी नहीं। दस नंबर दिया जाना उसकी नया बात।
इस पे ऐसे तो दिस इज पिटीशन seeking selling the order date 11/9/2015 by which though the Supreme Court has permitted to withdraw, has permitted the petitioner to withdraw the suit, but liberty as prayed by the petitioner has been declined. It is contended by the counsel the suit filed by the petitioner was sought to be withdrawn in view of the changed circumstances and a prayer was made to institute the fresh suit. And on this prayer, the prayer has been partly acceded to by the trial court, and though the withdrawal is permitted, but liberty has been declined. Counsel contend that the reasons for filing of this suit are clearly mentioned in opening paragraph of the ensuing order, and the aforesaid reason clearly reflect that, taking into consideration the changed circumstances only, the suit was sought to be withdrawn, and therefore there ought to have been permission to file a suit. And taking, there is no appearance parallel. There is no appearance on behalf of the respondent, though the respondents have been served, taking into consideration the records, it reflect that the liberty has been declined to the petitioner by the trial court by the interim order. It is mentioned in the opening paragraph of the interim order that an amendment application was moved during pendency of this suit. The said application for amendment was declined by the trial court, and therefore, in view of this subsequent event, the prayer was made to withdraw the suit by the present petitioner. His said permission has been declined by the interim order. So it is this court is of the view, when the reasons were detailed in the application for withdrawal of the suit, the grant of liberty ought to have been extended by the trial court to file the suit, inasmuch as, the reasons for withdrawal of the suit and also need to file fresh suit were elaborated in the applications. Hence, the order implemented 11/2015 P1 stands modified to the extent that apart from withdrawal of the suit, the petitioner herein would be at liberty to file a fresh suit concerning the same cause of action. ये लेकिन 15 का ऑर्डर तो आपसे टच में है कि अभी वो लिटिगेट करना चाहते हैं कि नहीं?
हम इंफॉर्म करेंगे में लास्ट में
अरे लॉस नहीं है तो आपसे टच में नहीं है तो हो सकता है कॉज ही ना हो, क्योंकि ये तो 15 का ऑर्डर है। या तो आप इंस्ट्रक्शंस ले लें, क्योंकि हो सकता है वो खुद ही नहीं बिलिंग परसू कर रहे हैं, नेक्स्ट वीक रख देते हैं, क्योंकि इस ऑर्डर से भी कोई मतलब नहीं निकलेगा अगर वो टच में नहीं है आपको। नहीं, पहले आप पता कर लीजिए वो इंटरेस्टेड भी है कि नहीं।
इंटरेस्टेड तो 20 दिन से पहले, अब अभी वो नंबर नहीं, संपर्क में थे पहले, तो उसमें इंटरेस्टेड तो क्योंकि उनका मकान पूरा उनके उसमें।
और बात नहीं होगी कंप्यूटर। It is the respondents having been served on. I have not made any attempt to enter appearance before the court and file counter to the petition. The assembly of the court. तो that is that. उसके बाद वो मॉडिफाई वाला ऑर्डर करके with the aforesaid disposal of next. Replies filed at the request of counsel for state release the matter in the next week. Week commencing 13th of July. It is made clear that no further adjournment shall be granted to state on the next date of listing. IR if any to कोई IR है क्या? इसमें 96 से
99.
इसको कर दीजिए नन नन नेक्स्ट वीक कर देंगे। नो अपीयरेंस रिपोर्ट में अलग अलग होगा। 97 बताइए। कोई इन्फ्रक्चुअस तो नहीं हो गया है? Aspirate by petitioner is the matter in the next week. No further adjournment shall be granted as the case is pending since 2015. Next. Infractures तो नहीं हुआ अभी। अभी पिटिशनर प्रेस करना चाह रहे हैं, टच में है आपके कि नहीं? पिटिशनर
हाँ सर,
तो फिर आप रिप्लाई दे दीजिए। 3 weeks time to state to file return as the last intelligence list in week commencing 20 July. Hello, next. Counsel for petitioner is for granted 2 weeks time to bring on record legal representative of the deceased litigant list after 2 weeks. This is possible. ये भी वैसे ही है, इसमें भी कर दीजिए। As read by petitioner is the matter be commencing 13 July. No further adjournment as the case is pending since 2015. अगला ये लगा था counsel. There is an additional note of the counsel for petitioner is the matter in the next week. No further adjournment as the case is pending since 2015. Next. None for the petitioner. Place the matter in the next week. If no appearance, this court may consider dismissal. अगला पुराने ऑर्डर देखिए, पुराने ऑर्डर ERP में नहीं है पुराना। 103 नंबर नेट पे तो कोई भी ऑर्डर नहीं। next week. None for the petition. This is the matter in the next week. If no appearance, this court may consider dismissal. अगला. तो पुराना दिखा था. हाँ. देखो ना इसकी फाइल. इसमें है ऑर्डर. None. For petition is the matter in the next week. If no appearance on the negative, this court may consider dismissal. Next week. इनका respondent नाम डालो. अगला बोल.
Order you want. Parity between one of the cases of the magazine.
हाँ.
I'm getting the supported and deciding on 2024, the case of the petition can also be considered for permission time scale of the ignoring the fact that the petitioner has recently criminal trials specifically. So what should I check the case status of this particular case here also? In this, your lordship, one of application for recalling was filed, though not by the petitioner lordship, but by the not by the respondents therein, but by the petitioner your lordship.
In Nagendra case.
Again, I have included that particular application for recording in the request serial number 1. Your lordship, on that the notice was issued to the state government, and that was waived by the because the government had because present department. Your lordship, so that case is now still pending for adjudication. In that case, the issue was that how the eviction period was passed, in which already the projection was there, your lordship, and however the court on this honorable court directed that for consideration despite that particular wrong. But that case still has not been the particular application of it was not attained finality. Whatever the order, Indian order that order.
जब तक अटेंड पेनल्टी तब तक तो होल्डिंग फील्ड या तो आप जब तक रिकॉल ना हो मॉडिफाई ना हो तो आप
Your lordship, the ground is that this order your lordship was passed on the first date of at the stage of the admission your lordship. And your lordship, there was a criminal case under the Prevention of Corruption Act against the petitioner. So your lordship, for that, since the promotions were not holding your lordships, because of the dispute that is going on, the notification which is there in the initial RP2 your lordships. On that basis, we were giving the officiating charge to lordships. And pursuant to this notification, we have issued the circular your lordship. That is there in the initial P3 your lordships. And in that your lordships, this particular criteria was there your lordships.
there, Mr. Shukla, so far as merit is concerned, this court did not.
That is the notice 7 point is there. यदि अपराधिक प्रकरण पंचमन होकर विवेचना नहीं है अथवा न्यायालय में लंबित है तो संबंधित बात नहीं।
All are the employees of time office and have retired from the time office. Some person again functioning and check will have been extended the benefit by the department done by spending extended.
नागेंद्र बहादुर को मिल गया है
मिल गया विजयपुर को भी दे
ऑर्डर है वो
नागेंद्र बहादुर का जो बेनिफिट दिया था उसको इन्हें विड्रॉ किया था तब नागेंद्र बहादुर ने पिटीशन फाइल की थी हाईकोर्ट ने उसको रख को ऐसा कर लिया they had already done it. और विजयपुर का है I got the counsel of in that petition. विजयपुर को भी एक्सटेंड कर दिया तो मैंने कंटेम्प्ट लगाई कंटेम्प्ट कंप्लाइंस को पेश किया वो भी एक्सटेंड होगा मैं स्टेटमेंट में आल्सो टेकन ऑन फॉर
point out that in these cases which the
विजयपुर का केस मैन केस था नागेंद्र बहादुर सब्सिक्वेंटली in the Nagan case, body respect followed the principal recommendation.
Your Lordship, these cases which the London Council is pointing out, Your Lordship, these cases were not pertaining to the prevention of corruption, Your Lordship. We have distinguished our case from these cases, and our pleadings to that effect, it starts from para number 8, Your Lordship. If I may be permitted to read, Your Lordship. That two parties, as the applicability of order passed in the case of Nagendra Bahadur Singh superintention, the same is not applicable in the case of petitioner. The facts of the case of the Nagendra Bahadur Singh are quite different. In fact, the order passed in the case of Nagendra Bahadur Singh is based on the judgment passed by the coordinate bench in case of Vijay Kumar Pun versus Bishop India. From the reading of judgment of Vijay Kumar Pun, it can be gathered that the same has been passed by placing reliance on the case of Umesh Prasad Singh, judgment passed by the division bench of Allahabad High Court in WP number 12. So, the fact of the case of Umesh Prasad Singh that a criminal case was registered against the petitioner in the year 1999 under section 217 to 1801 and 123 of IPC in the proceeding under section 482 CRPC. The Honorable Court has stated these further proceeding of criminal case. It is also gathered from the perusal of the case of Umesh Prasad Singh that during the pendency of the criminal proceedings, he was given out of turn promotion on 14/9/2006 on the post of inspector. It is also gathered from the fact of the case of Umesh Prasad Singh that a criminal case was registered in the year 1999 at the behest of the, and therefore under the given circumstance, the division bench of Allahabad High Court has admitted that under such circumstances, the recommendation of promotion cannot be put under seal recovery. So far as the case of Vijay Kumar Punj is concerned, in which said case, the criminal case was registered in the year 1996. The fact of the case was that the petitioner Vijay Kumar Punj, as part of the substitution Dhyan to praise accused, at that time, a criminal case was registered against him under section 364 and 342 of IPC at the behest of British anti-social elements of UCA, Kamalul B. From the perusal of the case, facts of the case of Umesh Prasad Singh Vijay Kumar Punj is that the facts of these cases are slightly different than the facts of the case of present petitioner Prakash Singh Yadav. So far as the case of Nagendra Bahadur Singh, on which the petitioner is relying, can be saying that the criminal case was registered in the year 1996. And during the pendency of the same criminal case, certain benefits were extended to him, such as wide order dated 18 to 2030 and so and so. Third term of the thing was running. However, in the count of pendency of criminal case which was registered in the year 1996, the department wide order dated the only three orders. It is relevant that the criminal case of the 1996 was registered against petitioner Nagendra Bahadur Singh as part of search. He was visited Jian to praise him. The case was registered against him at the behest of anti-social elements, whereas the case of Nagendra Bahadur Singh was similar to the case of Vijay Kumar Punj. And thus, the Honorable Court has directed the decision of the department in withdrawing the promotion is back in the IP. So far as the present
क्रिमिनल केस का हुआ क्या आपके? अरे नहीं, क्रिमिनल केस का क्या हुआ जो आपके खिलाफ था? क्रिमिनल केस इज पेंडिंग.
No data matching certificate. And also they have also recommended a policy or grant. Yes. And lots of scope kindly P10 and lots of P4. They have also recommended for granting the benefit by the department and P4 pay number 40 lots. They have forwarded my matter for granting the benefit pay number 41. My name is P number 3. The whole case है pending रहेगा. चालान case नहीं हुआ है अभी तक 5 साल से ज़्यादा हो चुके हैं. And they have extended in such circumstances the benefit of promoter time statement with case is pending under PCF and but another section also. This is not issue. Issue is that the other case is pending or not. Case was pending there and there. अगर विभागीय जांच भी ने खत्म कर दी हमारे खिलाफ P10 से. P10 का पेज नंबर.
It was disposed of on the first day. Then both of you argue on merit. Let it be restored to its number. This is a review petition seeking review of the law.
Now I am going to the data. And since in the
What are the court has already been given direction to the respondent if petition found eligible otherwise. So they have liberty. They have to consider. अभी भी ने हमारा नाम भेज दिया है promotion के लिए. अभी भी भेज दिया है. Second statement में also to take over record. They have forwarded my name for granting the money. Why they have filed legal petition for all this body only within the legal petition. I am full knowledge not to take that petition. I have communicated my name and also been forwarded. सर इनका लोग इसमें भी चलता रहेगा जब तक उसका जीवन रहेगा वो खत्म नहीं होने वाला and in such circumstances when Vijay Kumar Sponge honorable court has held that in such circumstances due to the long pendency of the criminal case it is appropriate to direct the authority to grant the benefit and consent subject to outcome of तो मैं एलिजिबल होते हुए भी डिप्राइव और 3-4 के द्वारा ने मेरा नाम भेज दिया एटीआर भी भेज दिए पीटीआर ने मेरे भागी जांच वो खत्म कर दी
अब ये सब तो आप मेरिट पे वापस बताएंगे जब इनको सुनेंगे, बिकॉज पहली डेट पे ऑर्डर हो गया था इनकी लाइट ऑफ नगेंद्र बहादुर.
But according to clearly mentioned, if found otherwise illegible, they have the right job. To pass appropriate order.
अदरवाइज नहीं, लेकिन उन्होंने कोर्ट ने ये भी बोल दिया ना, इग्नोरिंग द पेंडेंसी ऑफ द क्रिमिनल केस दैट इज क्रिएटिंग प्रॉब्लम फॉर देम.
Those cases.
हाँ तो फिर ये इसको या तो इसको ये मॉडिफाई कर देते हैं कि आप if found illegal including the factum of registration of a criminal case तब वो डिसाइड करें. ऐसा क्लैरिफाई मॉडिफाई कर दें.
सर यहाँ पे अगर केस नहीं चलेगा तो सर उनके
नहीं, अभी आपका राइडर ये आ रहा है कि in view of नागेंद्र प्रताप सिंह there are observation by the court that the factum of registration of a criminal case is to be ignored. हाँ तो अगर if that can also be taken into consideration फिर तो आपको कोई डिफिकल्टी नहीं. हाँ, उतना मॉडिफाई कर दें. वो नागेंद्र को पूरा अलग कर देंगे, पूरी लिबर्टी आपको दे देंगे कि आप कंसीडर कर दें. समझ गए? बिकॉज योर ओनली डिफिकल्टी इज दैट द पेंडेंसी इज टू बी इग्नोर्ड. This is a petition by the petitioner seeking order, recalling of the order passed by this court, dated so and so, and WP so and so. It is contended by the counsel that on the very first date of hearing, this court dispose of the petition with a direction to the respondents / review petitioner herein to consider the case of writ petitioner for promotion in the light of decision of coordinate bench in WP 7072 of 24 Bahadur Singh versus State of MP. It is contended by the counsel that the nature of criminal cases which were registered against the petitioner and those petitioner in Vijay Bahadur Singh as well as Vijay Punj.
Yes, we have to.
Nagendra Bahadur and Vijay Punj were different in nature. It is contended by counsel for the state that this aspect could not be brought to the notice of this court. It is the further contention of the counsel that an application seeking modification of final order in Nagendra Bahadur Singh case has been filed, which is pending consideration. Therefore, the order deserves to be reviewed. It is contended by counsel for the respondent that the case by Lokayukt, has been registered against the present petitioner. The present petition has attained the kitni age हो गई writ petitioner? 30. The petitioner is approaching the date of retirement. Therefore, as the order is innocuous, the review petition deserves to be dismissed. Counsel for the petitioner further submit that if the review petitioners are agreed by the direction pertaining to consideration case of the petitioner, while ignoring the pendency of criminal case is concerned, the petitioner respondent has no objection if the order is modified, while extending the liberty to the present petitioner, to take decision as regards eligibility of the petitioner for grant of promotion. eligible. Taking into consideration the aforesaid, this court is of the view. This court is of the view that taking into consideration the aforesaid, taking into consideration the reports that reflect that this court disposed of the petition in the light of order passed by coordinate bench in Nagendra Bahadur. First off, there were direction by this court to consider the eligibility of the petitioner for promotion and ignoring the factum of criminal case. However, as the petitioner has now observed that the absolute liberty is extended to the review petitioner to consider the case of the petitioner. The aforesaid order dated 19th of June 26 passed in WP is modified, and accordingly, the existing paragraph 2 of the order be deleted and substituted by following paragraph 2 per deleted. Considering the aforesaid submission, the present petition stands to dispose of the direction to the respondent to consider the case of petitioner for promotion and benefit of time pay scale.
Presentation with respect to that and why what is referred to. So the preferred here.
Yeah, उसमें ऐसा करते हैं. Just dispose of the direction that the petitioner submits a representation afresh within 15 days. The respondent shall take decision on the claim of the petitioners regarding granting promotion and benefit of time pay scale. Stop. If the petitioner is ultimately found fit and eligible for the benefit which the petitioner is claiming, the same would be extended to the petitioner. The decision on the representation shall be taken within a period of 60 days from the receipt of representation, and if the petitioner is ultimately found entitled, and for the benefit and there is no impediment or embargo, the same would be extended within further 30 days. You can see that with the aforesaid modification.
I believe that he has also that in the case of Nagendra Bahadur, they have filed an application for the body for modification of the order. It's and also till the Honorable Court has not modified or recalled the order in Nagendra Bahadur, the principal letter will like give a consent like that.
अरे तो वापस हो गया, इसलिए तो बोल रहा वापस हियरिंग कर लें. तो वो अब ऑब्जर्वेशन नहीं देंगे, इसलिए तो कॉम्प्लिकेशन आते जाएंगे. नहीं करते. No opinion on merit by this court. Disposal. उसी में आ जाएगा पेरेंट. No opinion merit के बाद substitute आ रहा है.
Promotion as an
हाँ, टाइम स्केल पे है ना, प्रमोशन एंड ग्रांट ऑफ टाइम पे स्केल दोनों आ गए. अगला बताइए. P7 पेज नंबर बताइए. क्या क्या ऑर्डर है? हाँ,
यहाँ से कलेक्टर साहब का साहब 2/2/2026 को उपस्थित होते हैं. 23/2/2026 को रिजल्ट कर लेते हैं और 23/2/2026 को ऑर्डर शीट कटी हुई है. इसको मेरे साइन है. साथ में लिखा हुआ है संदर्भ प्रतिवेदन एवं दस्तावेज प्राप्त करने की समझ. ये इन्होंने काट दिया और आगे लिखते हैं ये दस्तावेज दिए जा चुके. ये दस्तावेज कभी प्रदान नहीं हुए. इसमें जो कॉलोनी सेट का अभिमत का प्रतिवेदन था और भी पंचनामा जो हमारे डायरेक्टर कभी नहीं दिए. उसके बाद आगे मैंने उसमें 2 एप्लीकेशन फेस किए, एक 7/11 का और एक एप्लीकेशन फेस का डॉक्यूमेंट प्रदान किए जाने के बाद उसके बाद ट्रायल के लिए दोनों एप्लीकेशन के विषय में सुनवाई होती है 23/2/2026 में. 23/2/2026 की ऑर्डरशीट में, क्योंकि वहां पे ऑर्डरशीट पहले लिखते नहीं है, इसलिए मैंने साइड में मेंशन कर दिया था. 2 आवेदन दस्तावेज प्रदान किए जाने के तुरंत क्षेत्र अधिकार पर 7/11 का आवेदन फेस गुण अवगुण पर आवेदन निराकरण एवं दस्तावेज प्रदान किए जाने हेतु आवेदन किया. इन द मीनवाइल मैंने सर्टिफाइड कॉपी के लिए एप्लीकेशन फाइल किया. सर्टिफाइड कॉपी के लिए एप्लीकेशन भी पेंडिंग था, डॉक्यूमेंट्स की प्रति भी नहीं प्रदान की गई और उसी डेट पे ऑर्डर के लिए रिजर्व कर लिया.
mean, my lord, it is a settled principle of law. The actor cannot direct to register the FIR. File and complaint. अगर ये proper trial नहीं करते तो complaint case file कर सकते हैं। reference को मैंने चार document download किए हैं, which says कि competent authority cannot direct this to register land.
There is provision, statutory provision of lodging of FIR. Lie.
7-11 के विषय में मैंने एप्लीकेशन की थी, मैं उस पे जजमेंट आऊँ सर, उसमें कहीं प्रॉपर्टी क्लेम कर दी थी।
अरे आप ये बताएं कि लॉ है, रूल्स कौन से लगे जिसके अंदर डायरेक्शन हुआ क्रिमिनल केस रजिस्टर करने का? 2014 के रूल लाए हैं।
2014 के रूल से मैंने नोट किया।
कौन सा रूल है?
2014 Section 61 of the rules to consider a clear honorable source as part several reading order, which is defense code and defense file, can be applied. Even this honorable court has direct authority has no power to direct to register the name. कि ये ट्राई कर सकते हैं, ट्राई करने के बाद यदि बात की रीजन फॉर नॉन लीगल तो वो एफआईआर के लिए परिवाद दाखिल करेंगे कॉम्पिटेंट अथॉरिटीज। दे आर नॉट जुडिशियल मजिस्ट्रेट, they have no power under section 156(3) to direct and register the FIR or investigate the matter. Because it is a district.
Yes, बताइए मिस्टर शुक्ला।
Reference में can be applied.
This order has been passed under the rules of 2014 law, which has been enacted in pursuant to the power given under Panchayat Raj Act. It is given in the lordship's valued law. Madhya Pradesh Panchayat Raj एवं ग्राम स्वराज अधिनियम 1992 की धारा 95 की धारा उपधारा 1 के साथ पठित धारा 61 द्वारा प्रदत्त शक्तियों को प्रयोग में लाते हुए राज्य सरकार एक्ट द्वारा निम्नलिखित नियम बनाते। The lordship the rules have been made exercising the powers under the act, your lordship, and your lordship under the Madhya Pradesh Panchayat Raj revision rules, your lordship. It has been clearly provided, say where it has been otherwise provided in the act or rules or bylaws made thereunder, an appeal shall lie in the case of an order passed by the collector under any provision of the act or rules or bylaws made under to the commissioner. So he can prefer an appeal to the commissioner.
Alternate remedy cannot operate as a bar. There is a
look into these aspects.
The commissioner has no power to conduct the trial. Collector has power to conduct the trial. कलेक्टर साहब ने 7-11 के एप्लीकेशन पे और डॉक्यूमेंट प्रदान किए जाने के एप्लीकेशन पे मामले को सुना और फाइन ऑफ रिजल्ट कर दिया। फाइन हम अपने केस को कहाँ कैनवास करेंगे, कमिश्नर न्यायालय में या ट्रायल कोर्ट में? यार जब एक बार देखें ऑर्डर शीट कटी हुई, ऑर्डर शीट मेरे सामने जो ऑर्डर शीट लिखते हैं उसको काटते हैं, फिर दोबारा ऑर्डर शीट लिखते हैं। और लास्ट में भी मैंने जो हमने जो लगाई है
वो देना सेक्शन 61 पंचायत राज।
इस पे मैंने लिखा है कि 2 एप्लीकेशन पेश हुए हैं, दोनों एप्लीकेशन पर सुनवाई हुई, दोनों और गोड़ापुर पे करके के सुना चाह उन दोनों इंस्ट्रक्शनों को दरकिनार करके आगे से रिजल्ट कर दे रहे हैं अल्टीमेटली। और 1 महीने के अंदर ऑर्डर 2 तारीख को और 2 तारीख को हमें अपील होने का मौका मिलता है और 1 महीने में 23 तारीख को ये रिजल्ट कर लेंगे। फिर क्या ट्रायल कर रहे हैं आपके पास जो प्रतिवेदन आए हैं उसकी प्रति आप सप्लाई कर रहे हैं ना, कोई चीज दे रहे हैं और सर्टिफाइड कॉपी जो हमने फाइल की सर्टिफाइड कॉपी जो हमने फाइल की उसके डॉक्यूमेंट भी हमें आदेश पारित होने के बाद मिल रहे हैं। ये जो कॉपीज मैंने लगाई हैं ये सब ऑर्डर पास होने के बाद हमें मिल रही है। वो कॉपीज जो हम सर्टिफाइड कॉपी ट्रायल के दौरान लगा रहे हैं कि हम ये दस्तावेज दे दिए ताकि हम अपने केस को कैनवास कर सकें। तो अपीलेट अथॉरिटी केवल नीचे से रिकॉर्ड बुलाएगी, रिकॉर्ड में ये 4 दस्तावेज जाएंगे और वो भी ऑर्डर पास कर देंगे। हमें अपना केस कैनवास करने का तो कभी मौका ही नहीं मिलेगा और सो फॉर नोटिस इज कंसर्न, हमने जो एसडीओ के सामने अपना जवाब दिया था, एसडीओ के सामने जो हमने जवाब दिया था उस पर हमने सारे क्लियर लगाए थे, उन दस्तावेजों को कंसीडर नहीं किया।
मेरे भाई तो आपका दोनों तरफ का डाइकोटोमस आर्ग्यूमेंट हो गया। अभी तो आप कह रहे हैं अपॉर्चुनिटी दी, फिर कहते हैं एसडीओ के सामने।
एसडीओ ने इस बात पे सुपर किया था कि क्या आपने अवैध होने में, उसके बाद सिर्फ ये है कि वेदर मामला कलेक्टर के यहाँ पेश किए जाने योग्य है, भेजे जाने योग्य है कि नहीं, इस पॉइंट पर सुपर नहीं किया। हमने उनको बताया, उन्होंने कलेक्टर के सामने मामला फॉरवर्ड कर दिया। 2020 में सुपर नोटिस जारी हुआ था एसडीएम, और एसडीएम से ये सामने से मामला आता है 2026 में कलेक्टर साहब के पास, और कलेक्टर साहब के यहाँ दो फॉर्म अपेयर होते हैं और दस्तावेज मांगते हैं, और 23 को हम जो एप्लीकेशन पेश करते हैं और हर्ड रिजर्व फाइनल ऑर्डर पास हुआ। तो कलेक्टर साहब जो कॉम्पिटेंट अथॉरिटी है पंचायत अधिनियम के अंतर्गत, उनके यहाँ मामला पंजीकृत होता है 2026 पर 23/2/2026 को फाइनल ऑर्डर पास हुआ था, डिस्पाइट द फैक्ट वी हैव फाइल्ड 2 एप्लीकेशन, वी आर आस्किंग द प्रॉपर्टी ऑफ हेयरिंग, वी आर आस्किंग फॉर द डॉक्यूमेंट, वी आर आस्किंग फॉर द टाइटल यूनिट। हमने तो सब दिया था, ये भी पूरा एसडीएम है जो पावर टू प्रोवाइड। और लुक दी कंडक्ट ऑफ द कलेक्टर, हमारे सामने ऑर्डर शीट कुछ और लिख रहे हैं और आप उस ऑर्डर शीट को काट के हमारे बिहार में कोई ऑर्डर शीट लिख रहे हैं। ये लास्ट वाली ऑर्डर शीट हमारे सामने नहीं लिखी थी, इसकी वजह साइड में पूरी चीजें मेंशन कर दी थी कि मैंने इन पे चाहा और ये चीजें मांगी। इतना लिखे जाने के बावजूद हमारे फाइन 7 दिन की पेशी दे देते साहब, हमें अपने दस्तावेज अपने वहाँ जो दस्तावेज है वहाँ दस्तावेज दे देते हम। हमने क्रॉस एग्जामिनेशन का ऑप्शन मांगा था बिहाइंड द कंस्ट्रक्शन
किताब पंचायत आप
लेकिन कोई एप्लीकेशन फाइल होता है उसका डिस्क्लोजर कलेक्टर साहब करते हैं, क्योंकि लिखित रिजर्वेशन में समझना सारी बात है। हमारी स्क्यूरिटी रिमाइंडिंग को फॉर्वर्ड करते हैं, एप्लीकेशन फाइल करें, सबमिशन को मैं तो फाइल ऑर्डर के साथ करें, यहाँ तक दस्तावेज प्रदान किए जाने के आवेदन वगैरह कर दिया, फाइल ऑर्डर के साथ करते हैं। 20 दिन के अंदर पूरी ट्राई कर दूँ, केवल एक अपॉर्चुनिटी ऑफ हियरिंग, एक पेशी लगाएंगे, डॉक्यूमेंट सप्लाई। तो हाउ विल डील विद कलेक्टर्स? वी हैव नो अल्टरनेटिव। अल्टरनेट रेमेडी कमिश्नर साहब के यहाँ जाके ट्रायल नहीं हो सकता।
ट्रायल नहीं, तो उन्होंने ट्रायल नहीं करना,
डायरेक्ट टू रजिस्टर दिया
एफआईआर रजिस्ट्रेशन
और कॉलोनी का प्रबंधन लेके
लॉर्डशिप्स कंप्लेन ही के तौर पे जाएगी, लॉर्डशिप्स
नहीं जाएगी।
कंप्लेन जाएगी वो एफआईआर का
डायरेक्ट एफआईआर दर्ज होगी तो
रजिस्ट्रेशन ऑफ एफआईआर जो भी ट्रायल
लेकिन यहाँ पे जो रेफरेंस है
तो 61 डे पे कुछ ऑर्डर करें ना, इतना अगर 61 डे को कुछ अपन कंसीडर कर भी पंचायत राज में सेंट्रल ऑर्डर दिए अगर ऐसे ऑर्डर्स में करेंगे प्रोसिक्यूशन मिस्टेक या सिमिलरिटी आ जाएगी। नोट कर लो सेक्शन 61 डी पंचायत राज। The file reply only prosecution part shall remain state for registration of file. Remaining file reply. देख रहे हैं order implement so far it relates to registration of FIR. Comma shall be kept in place. But 27.
It's on the basis of the typing mistake that irritate this
पास ओवर आपने कराया था हैं? Why you got it?
There is already difficulty with me. There is some typing mistake on in the name of the husband and father. Admittedly, on the date of the submission of the application and the final during the finalized list, his name is not mentioned in the BPL. BPL card submitted by him, the father name and the grandfather name is different. And considering all these things, the collector had advised the part the order and directed to raise the state. And he see
the prevalence is 2011 itself. Even though that there is the interim order in the paper application and my client.
Let then interim order be vacated.
Sign of the list.
It will not be, the court will not function as per your convenience. By first round, it was passed over at your request. The other side is waiting since morning. Or you pay cost, it will be adjourned. Subject to 25,000 payable cost to be. The case was passed over in the first round. And your request will not be entertained. If you make a request at 4:30, it will not be entertained. The order will not be changed. Already made a prayer. This is a second round. On first round, the counsel for petitioner sought pass over. The case was passed over. However, in the second round, the request is made for a second pass over. The counsel for the respondent, who was available in the first round, is also available in the second round. The matter in the first round was taken up around 11 a.m. in the morning, and now the matter is being taken up at around 3:45 in the evening. Stop. Apparently, the petitioner, in spite of apparently, and the petitioner approach towards the matter is scheduled according is the case in the case is adjourned subject to payment of cost by the petitioner to the respondent to the tune of rupees 10,000. I have to continue. It is made clear that the matter on the next date shall be taken up for hearing only upon production of receipt regarding payment of cost in terms of this order. Clearly. Next Wednesday. Next Wednesday. Not 25. And for the petitioner, the case is taken up. Even when the case is taken up in the second round, it stands dismissed for want of prosecution. Next. 17. कौन सा एफिडेविट देना हो? क्या रिफंड हो गया? कर दीजिए फाइल नेक्स्ट वीक में as spread by petition is the matter in the next week. हाँ उनको एफिडेविट फाइल कर लेंगे नेक्स्ट वीक में. नेक्स्ट वीक is the matter in the next week. How long he is supposed to wait? In first round, we sought a passover. He was there in the second round. अभी करिए फिर बताइए फाइल. You are ready? Yeah. बताइए.
If I found the reason for my feedback that we were not there, the audit was because we had signed the career rematching day for the 11 months. The decision was right. Thereafter, the information with regards to the fact that the matter has been filed did not receive we reduced it from that. Therefore, she could not place much point on your object. And the object conduct now. However, the issue is not issue is with regard to grandfather's name in the BPL side.
The petitioner's father name was there. It is not in dispute that the BPL card is not false. I don't know what means. The grandfather's name was written as Babua Ram Arvind instead of some other name, which was subsequently corrected. Those corrected documents were what we have filed in this petition also. We could not file it there because we did not find the information that we need. And so if there was,
You had filed written in the petition or not?
we did not, my knowledge of it, we did not receive information regarding filing. The state had filed it.
No, but you were already, the notice of that case was served. But on last few date, there was no appearance on your behalf.
Notices were served to the council, my lord, the council, probably all, so they have been told that, did not inform that the case is. वो चाचा के through council engage किया था, and then.
No. You had filed because petition was filed in 2011. निकालिए इसकी.
We have gone there, some cases of the debit number of times they appear and we try to find the reply, but no reply.
Reply was not filed.
And because of this last two things, the person which council mark, that is the book. You considering all these steps, the final are part in this.
Yes.
So this ground पे
हाँ बताइए.
Lordship order is on, as in its art, from page 26 onward.
Yes.
The main issue has been dealt by Lordship in paragraph number 8 and 9.
Yes.
Para 8 comments. The written of the record reflects that on the date of submission of the application, the candidates were required to possess the requisite eligibility criteria mentioned in the guidelines. The BPL card which was produced by the private respondent, seeking appointment contained name of one Devendra Kumar, son of Bhagwara. It is undisputed that the name of the husband, allowed at that time when it was calling the petitioner was then unmarried man. So his father card would be applicable for that. Name of the husband of the private respondent is Devendra Kumar, allowed it has to be father. But his father's name is Ramadhar and not Babua Ram. Evidently, as the BPL card produced at the behest of the private respondent was not in respect of the husband. Although it was not required to be that of the husband because he got married in 2011. The process was from 9 to 10 months. So her father's of the private respondent, collector Siroli did not committed any error while passing the order dated 3/4/2011 continued in its. The said order could not have been interfered with the additional commission of Viva. The additional commission Viva was required to appreciate that on the date of submission of application form, there exists no valid free card. Issue in favor of the family members of the private respondent or the respondent. If the card which was annexed to the application form did not contain any description of the family members of the husband of the private respondent, and such cards could not have been.
On the date of submission of application, you are married or not?
Unmarried.
You are unmarried.
I was unmarried.
Then it requires another inquiry. If you are unmarried, how you produce this card in which your name of your. No, you read again. What is not your father? You read again, please.
This is what we say that the error has threatened that Akshita considered it as husband's card. No, in fact, it is my father's card.
Take the word husband in the title listing. Because this from the collected from my phone. The this is submit the BPL card in the name of the Ramadhar, son of Bhagwara. Bhagwara is the not the grandfather of this name. And
रामोदर सन ऑफ बबुआ राम नहीं भाई. देवेंद्र कुमार, ये तो अब आप और कंफ्यूज कर रहे हैं.
देवेंद्र कुमार is son of Ramadhar in place of the Ramadhar Bhagwa Ram card is mistake.
अरे भाई देवेंद्र कुमार सही है, लेकिन दोनों की वल्दियत गलत आ गई.
That's why the collector considered this thing.
अब ये बताइए कि देवेंद्र कुमार उनके हस्बैंड है कि फादर है? देवेंद्र फादर है. नेम ऑफ द हस्बैंड ऑफ, ये गलत आया टाइपिंग.
जी ये गलत हुआ है.
फादर ऑफ द देवेंद्र कुमार, बट हिज फादर्स नेम इज. अरे ये भी फिर गलत नहीं हुआ. इस लाइन को आप मिस्टेक कह रहे हो ना. पढ़िए, फिर से पढ़िए कि जिसमें आप मिस्टेक बताना चाह रहे हो. अरे जिसमें भी आप पैरा 80 में मिस्टेक बता रहे हैं ना, वहाँ पर उतनी लाइन बता दीजिए जहाँ मिस्टेक आ रही है.
Name of the event Kumar. It is undisputed that the name of the husband of the private respondent, Deven Kumar, but his father name is Ramadhar and not Bhagwan.
तो ये कहाँ मिस्टेक है?
Husband word is Ramtu.
क्यों? हस्बैंड का नाम पहले बताइए क्या है? अरे हाँ, हस्बैंड का नाम बताइए. लेडी तो एक ही. हस्बैंड का नाम, हस्बैंड का नाम कैंडिडेट की. अरे प्राइवेट रिस्पोंडेंट के हस्बैंड का नाम क्या है?
जो रिव्यू पिटिशनर सर,
नॉट, हाँ रिव्यू पिटिशनर. हाँ रिव्यू पिटिशनर के हस्बैंड का नाम क्या है?
सर उसकी शादी हुई 2011 में, उसके बाद उसका नाम है ब्रह्मनारायण दुबे. इसके अपडेट सर, इसके फादर से उससे क्लियर हो जाएगा. हमको
अरे भाई आपसे सिंपल सवाल पूछ रहे हैं.
इसके फादर का नाम है सर देवेंद्र कुमार, और फादर के फादर का नाम है रामाधान, जो कि लिख दिया गया है बबुआ. तो फादर के नाम में गलती नहीं है सर रिव्यू पिटिशनर के. उसके ग्रैंडफादर के नाम में गलती है, जो सर्टिफिकेट उसके फादर उसके सामने किया गया. Page number 20, which was then, which was subsequently verified also. मतलब we are filing of document also, wherein हमने certificate पे वो नाम लिख दिया. और आगे भी सर एक जगह और हस्बैंड का दिख रहा है, पैरा 8 की लास्ट की लाइन.
हाँ बताइए कहाँ पे आए?
मतलब कार्ड सर पेज नंबर 31.
पेज नंबर 13.
सर फर्स्ट पैरा की नीचे से चौथे नंबर. On the card which was annexed to the applicant form did not contain any description of the family members of the husband of the child.
हाँ
And such a part could not have been relied upon by the litigant. So sir, this is not a question because husband at that time was not married, so it has to be fathers. We say that apparent error has stepped in because probably father was out.
Page number 20.
नहीं, अगर ये करेक्शन है तो पैराग्राफ 3 में तो आपके कंटेंशन जो लिखे वो भी गलत है क्या? पैरा 3 में जो आपके आर्गुमेंट लिखे वो गलत लिखे.
Husband word गलत है.
लेट द ऑर्डर बी रिकॉल्ड देन.
In the order for matter collection. Because the matter travels from the collector to us. There is no dispute regarding the husband. The card, DPL card of certificate submitted by the register is found to be correct. Because of that, the collector was the order and subsequent.
Both of you argue it again, then let it the order be recalled.
I only.
हम उसमें रिटर्न दे देंगे तो हमारे
An application seeking a review of the author. It is contended by counsel for the review petitioner that as the review petitioner who was respondent number 5 in the case could not appear before this court, the order has been passed. It is contended by the counsel that, and paragraph 3 as well as paragraph 8 of the order, the court has proceeded to decide the matter under misconception that the BPL card status of the private review petitioner was disputed as she had not submitted was disputed as the name of her husband was not there. It is contended by counsel for the review petitioner that at the time of submission of application form, respondent number 5 was unmarried, and therefore there was no question of submission of a BPL card containing the name of the husband of the review petitioner. It is the further contention that this court that on account of error, this court has referred the name of the father of the petitioner, whereas the name of the father while terming him to be the husband of the reviewed petitioner. Therefore, the order which was reviewed in counsel for the respondent is opposed the fair. However, does not dispute the fact that there are some incorrect mention of facts in paragraph 3 as well as 8 of the order. If not taking into consideration the aforesaid comma as the this court while deciding the matter has taken recourse to the facts which are undisputedly incorrect as mentioned in paragraph 3 and 8 of the order, it will be conducive to rehear the matter on merit. Resultantly, the order dated so and so passed in WP so and so is recalled. Let the petition be referred to the original number and be posted for hearing in the next week.
Because then I will find a reply.
We commencing 13th of July.
Nothing but much. I was next to the board at my friend also. I was on my next one of time.
74. 74. हाँ बताइए. क्या चैलेंज कर रहे हैं आप? P5 क्या है? P5 what is P5?
P5 is not letter dated 5/6/2026 taken by the Transport Commissioner to all the regional transport authorities for cancellation of the registration which has been lawfully made below. After verifying all the documents, as per the provisions of section 55 of the legislation. Now, my submission here is that I have mentioned all the procedure below.
ये ऐसी और भी पिटीशन फाइल हुई है ना अभी ऐसा आइडेंटिकल पिटीशन. हाँ तो उसका नंबर दीजिए, उनके साथ रख देते, इसमें इंस्ट्रक्शंस ले लीजिए. अभी कल या परसों भी एक आई थी.
Challenge करने पड़ेंगे क्योंकि the entire taken is pursuant to the section 125C. केंद्रीय मोटर निगम मोटर निगम 1983. फर्स्ट पैरल में प्रोवाइड की ये प्रावधानों के तहत ही ये सब संशोधन किए गए.
सवाल ये नहीं है सर. सवाल ये आता है कि वो प्रावधान जो है कब नोटिस में आए. My lord may appreciate Milord. I'll take only the 5 or 7 minutes. Milord, the procedure is Milord that we purchase the chassis Milord from the dealer. Now, as per the law of the Motor Vehicle Act, the dealer has to do all the registration work. So he gets Milord documents, collect documents from us Milord, who submits it to the regional transport officer. The regional transport officer Milord, he verifies all the documents Milord, and as per the provisions of section 55 of the Motor Vehicle Act, Milord, he gives the registration to the dealer. And that dealer Milord passes over that registration to the owner of the vehicle. Yes. And since it was a chassis for passenger transport, Milord, thereafter Milord, there are certified builders by the association and under the Motor Vehicle Act. They are only authorized to build the body on the chips. So we find out who is that builder who is authorized and then approach him and he does the body building as per the specifications then prevailing. In our case, it was 55 was the application law at that relevant time. AIS 052. Similar, all those specifications were there, Milord. And after that, Milord, then the vehicle goes then those documents go to the registry authority after all this. And then seeing all the documents, I filed all the documents, all the certificates Milord are there, and Milord, but the requirements are Milord as per section 1147 part 2, the builder documents are there. The map is there, specifications are there, Milord, and what manner the body has to be built up, Milord. And so it was done, Milord, and the legal transport officer, Milord, will gave a registration. My vehicle is not registered. Thereafter, on the same Milord, he has granted a permit to me, a permanent permit, Milord, which is valid for 5 years, Milord. I am running my bus. Now what happens, Milord?
तो आपने ऐसे भी और भी you have filed identical petitions.
Milord, I have filed it in
उनमें क्या order हुआ?
petition only yesterday, Milord, for another complaint. What's the time issue?
इसमें भी नोटिस करके उसके साथ लगा देंगे.
और भी आएंगे इसमें नोटिस. इसमें मेरा एक निवेदन था सर, कि चूंकि मेरा परमिट है इसमें 5 साल का परमिट ग्रांट किया हुआ है, तो मुझे सर कितना निवेदन करना था नोटिस इश्यू करने के बाद नो कोर्सिव एक्शन में भी टेकन है. That much your lordship may protect me, because my lord, whatever is this, these letters, they have not been made public, my lord. My arguments are, my lord, submission is, my lord, that this annex P5 also is to the department, and neither we nor the body builder nor any person, they have not been published in any booklet gazette, my lord, and the government.
Mr. Shukla,
They were not known to
the
us.
only issue is that perhaps this amendment in statute or rules could be prospective. Perhaps this P5 is giving its retrospective. That is the difficulty. P5 का जो है that came into force with effect from 1925. इनका कहना है कि इसके पहले इन्होंने मॉडिफिकेशन करा दी थी पुराने AIS के हिसाब से. अब उन्होंने जस्ट वो जो अमेंडमेंट कोड के नीचे एक पैरा लिख दिया, वो देखिए, दैट इज क्रिएटिंग प्रॉब्लम. जो इंग्लिश पे कोड किया उसके जस्ट नीचे वाला पढ़िए.
संशोधन उपरांत प्रत्येक बस बॉडी बिल्डर को 13 या अधिक बैठक क्षमता वाली बस बॉडी के निर्माण हेतु उक्त मॉडल बॉडी निर्माण करने का टाइप अप्रूवल नियम 126 में विनिर्देशित किसी भी केस एजेंसी से कराया जाना अनिवार्य किया गया है. जिस कारण दिनांक 19/2025 से बस जिससे पर पृथक से निर्मित बस बॉडी की पंजीयन के समय से बस बॉडी का टाइप अप्रूवल सर्टिफिकेट अनिवार्य रूप से लिया जाना आवश्यक है.
नहीं तो ये जो आपने जो ऊपर से जो बॉडी चेसिस के ऊपर आई आप वाले केस में, तो उस 1925 के पहले की बात की आप वाले केस में.
केस में जो है हमारी 25/25 की है. 25 चेसिस was purchased not earlier to 19 and registered.
अच्छा, चेसिस पहले परचेस कर लिया, फिर बाद में हो केस कब होगा?
समय लगता है 3-4 महीने.
दैट इज द डिफिकल्टी. ऑल ऑफ देम दे बॉट चेसिस, मगर वो रजिस्ट्रेशन होते होते बीच अमेंडमेंट इंट्रोड्यूस हुआ. हाँ, ये तो समझ गए ना, ये डिफिकल्टी है.
आज की तारीख में भी 155 का किसी भी बिल्डर के पास में प्राइवेट बॉडी बनाने का लाइसेंस ही नहीं है, because they have to deposit about.
Issue notice to the respondents, PF 7 days returnable 4 weeks till next date of hearing, no coercive step shall be taken against the petitioner on the strength of letter/order dated 5/6/25 P5.
In respect of my
No coercive steps. No coercive step shall be taken. 76 बताइए, आपका है? हाँ बताइए.
matter pertains to that acquisition matters.
हाँ,
First appeal has been decided, thereafter second appeal has been made before the summary court. The compromise has taken place between the parties and even between the governing body. The basis of that filed application, that application is still pending. No amount has been discussed, no compensation.
इसमें रिटर्न आ गया है क्या?
Written again.
स्टेट का है? क्या कहा रिटर्न? क्या बोला है नंबर 3 ने? इनका प्रेयर यही है ना कि इन रिस्पेक्ट ऑफ टू ग्रांट कॉम्पनसेशन अंडर एसआरजी स्पेशल रिहेबिलिटेशन ग्रांट
Prayer clause number second.
सेकंड बची है ना, यही तो एक ही दैट इज द सोल प्रेयर। इसके बारे में क्या बोला?
Actually, the records of this is not available.
Online.
आपके पास नहीं
Record
रिटर्न वगैरह नहीं?
ERP पे डर
ईआरपी पे नहीं है? ओनली
There is
रिटर्न
only return.
ऑफिस डायरेक्टेड।
But no other record is linked with this.
अरे पिटीशन भी नहीं है ना इनका, तो पिटीशन भी ऑफिस डायरेक्टेड टू कम अपलोड द कंप्लीट रिकॉर्ड ऑफ द केस इंक्लूडिंग पिटीशन रिटर्न as well as other interlocutory application and ERP software. This is the matter in the next week.
This petition, may I request, Mr. This petition may be disposed of in the manner that we will file a fresh application before consulting authority.
Ah, yes, Mr. Shukla. In the, they will submit a representation in the prayer court.
In terms of authorship, second appeal.
Prayer court representation किसको देंगे?
Land acquisition.
Respondent number बताइए, respondent number.
Respondent number 3 lordship. Respondent number 1 is collector lordship and land acquisition.
नहीं, आप किसको दे रहे हैं? नंबर 3 को?
Number 1.
नंबर 1. नंबर 1 है ना? नंबर 1 15 60 30. नो opinion on merit. Dispose of. फ्रेश दे दी।
Which is like second appeal order kindly mentioned that in terms of second appeal.
वो तो आप लिबर्टी रहेंगी जो भी उसमें रिप्रेजेंटेशन में दो। पिटीशन शैल बी एट लिबर्टी टू प्लेस ऑल रिलेवेंट डॉक्यूमेंट इन सपोर्ट ऑफ रिप्रेजेंटेशन। आप बताइए।
Which was before the other statement 55. What it was in the past over, I could not hear. I apologize.
क्या हुआ? 35. You are ready?
My private respondent is there. However, it's arising out of revenue proceedings, and that is a second civil suit pending. Now, second appeal has got admitted to the court. Can be disposed of, but Mr. Rajiv Prasad Gupta is there from the opposite side.
कोई रिस्पॉन्डेंट के लिए कोई आया था क्या? इस पैकेज नंबर देखा ना?
But what happened, there was a mutation taking place.
हाँ,
It's my property undisputed. What happened in 1998, Bandobast Adhikari made a order.
this impugn order is in favor of the private respondent.
Yes.
Let him come. None उसमें कर दी श्री शुक्ला for petitioner, none for respondent, private respondent. Place the matter on Friday.
Next week.
Next week. IR if any to continue.